Well, hello everyone, and welcome back to One Civil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope today is the day I earn that subscription. For today's coverage, we are spending some quality time together, you and I, in Supreme Court land, because there were opinions that dropped on Friday that we didn't cover, and then some opinions that dropped today. So we've got seven, count them, seven Supreme Court decisions to discuss. So we're going to be here for a hot minute discussing the Supreme Court. So I hope you like Supreme Court because I got Supreme Court inside your Supreme Court. It's going to be fun and exciting. And hopefully I will explain it in a way that is all understandable. You know, one of the things I try to balance as a creator is how I explain things to try to make sure that, especially when I'm doing these sort of deep legal dives, that they're accessible to everyone. And I read the YouTube comments, and it's interesting reading the YouTube comments because you get, at least to what perceives to my mind to be a split, which isn't necessarily unexpected, but it does make it a little bit difficult for me as a creator to figure out what to do. Like, some people are like, I didn't understand this, I don't get it, it's all gobbledygook to me, I don't really understand what's going on. And then there's some people who are like, you said the same thing 4 or 5 times. You beat it to death. You beat the horse to death. Even after you turned it into glue, you were beating it to death so hard. And I'm like, okay, so how do I balance these twin things? Because I want to make sure I want to bring this law to you. I want to make it as accessible as I can. And I, of course, am well aware that I have a whole lot of background knowledge that the people watching this don't necessarily have. So sometimes, yes, I repeat myself, and then some people get mad I repeat myself, and then some people don't understand it anyway. So my continuing burden as a creator to try to make it as accessible to everyone as I can. So I will take your feedback as I try to make this as understandable as I can, and try to make it as accessible as I can, because the law belongs to everybody and everyone should understand it. And my job as a teacher is to make it accessible to you, no matter where you are. So I'm going to try. All right, great. Let's do that. Okay. So, yes, we were supposed to do Chat GPT this morning. That was originally the goal, but Ian didn't contact me saying that he was available this morning, because it's like, okay, Ian, will you be available? He's like, I think so. I'm like, okay. So he didn't text me to say, yeah, I'm available or something. So Chat GPT was the goal, but Ian didn't say he was available. And so I assumed he was not available as I checked my text messages again. So ChatGPT, I think, is better with company. I think it's better with company than me doing it solo. So in the absence of Ian, we will do Supreme Court review. So that's what we're doing. Yeah. So yeah, that's what we're doing. Great. All right. For today's United States Supreme Court decision, we deal with the issue of personal jurisdiction. When you are being sued, you have to be sued in a place in which you have sufficient minimum contacts. That case goes all the way back in Civ Pro, as we all learned from our Civ Pro classes. It's a case that is old and understood very well by whole people. International shoe and sort of personal jurisdiction. You have to have sufficient minimum contacts with a place, right? So if you're an individual, you can be sued in the state in which you live. That's a place where you can generally be sued over anything. And then in states in which you have specific contacts, but they have to be sufficiently minimum. In the case of a corporation, you can be sued in the place where your corporate headquarters are located or your primary place of business, which is typically like where your C suite is located. So many businesses, for example, are formally licensed in Delaware. That's where they're formally incorporated, but not necessarily where their primary offices are. So you can sue them either one. So we're kind of dealing with that issue today. Can we sue a person or a corporation in this particular place? So this deals with that issue of sufficient minimum contacts and what is sufficiently minimum. So let's get started with this. Robert Mallory worked for Norfolk Southern as a freight car mechanic for nearly 20 years, first in Ohio, then in Virginia. He is working on the railroad all the livelong day. The railroad, as one would appreciate, travels through multiple different states. He works in some of those states, including Ohio and Virginia. After he left the company, he moved to Pennsylvania for a period of time before he returned to Virginia. Along the way, he was diagnosed with cancer. Because he attributed his illness to his work, he sued his former employer under the Federal Employers Liability Act. So they're a railroad. As you would expect, railroads are governed by federal law because they travel interstate. They are sort of the original interstate commerce. And so much federal law applies when it deals with the railroads. So he thinks his employer is responsible for the harm he has befallen. He'd like to sue his employer. He'd like to sue them under federal law. Fine. So there is a federal law that provides compensation that permits railroad employees to recover damages for employer's negligence. My employer did it bad. They harmed me. I want compensation for the bad they did. Okie dokie. Critically, for our purposes, he filed suit in Pennsylvania State Court. Pennsylvania State Court. He worked in Ohio. He worked in Virginia, but we're suing in Pennsylvania. All right. He is suing them, even though Norfolk Southern is itself incorporated in Virginia and also headquartered there. So those states can be different. They often are different, but they don't necessarily need to be different. As I pointed out, many corporations are incorporated in Delaware, but their corporate headquarters aren't necessarily located in Delaware. So you can sue them either place. But in this particular case, that's the same place. They are incorporated in Virginia. Their primary place of business is Virginia. So it's Virginia or Virginia under international shoe and its subsequent case law. Okie dokie. So we can definitely sue them in Virginia. In fact, the Supreme Court suggests we can only sue them in Virginia. That's the case law up to this moment. But we're suing them in Pennsylvania. All right. So he sues them and he rested the suit on the basis that Pennsylvania's court exercised a personal jurisdiction over it would offend due process. So the railroad over here is like, this is not fair that we're being sued in Pennsylvania. Under the law as it exists up to this moment, we can only be sued in the place where we are primarily located, Virginia, or the state in which we're incorporated, Virginia. So your choices are Virginia or Virginia. He wants to bring it in Pennsylvania because he has a slightly better cause of action under Pennsylvania law. Pennsylvania law is more attractive to him. So he'd prefer Pennsylvania because the Pennsylvania law is a little bit more favorable to him in this particular situation. The railroad would very much prefer Virginia, and they're like, you literally can't sue us anywhere except Virginia. It would offend due process for us to be sued here. All right. Norfolk Southern noted that when the complaint was filed, the person who's suing resided in Virginia, and the complaint alleged that he was exposed to carcinogens only in Ohio and Virginia. So it isn't even the place of the injury. It isn't even the place of the injury on top of everything else. So first of all, you can only sue us in Virginia. Second of all, if you could sue us somewhere else, because that's the place of the injury. So maybe that's enough for a specialized case. Then Ohio, sure, because that's where that occurred, but you weren't injured in Virginia. So, or you weren't injured in Pennsylvania, rather. So why are you suing us in Pennsylvania? Because the law happens to be more attractive there. But what's your basis for saying the injury allows us to be sued there? All right. He points to Norfolk Southern's presence in Pennsylvania, noting that Norfolk Southern manages over 2,000 miles of track, operates 11 rail yards, and runs 3 locomotive repair shops in Pennsylvania. So Norfolk Southern over here, why is it fair you be sued in Pennsylvania? Well, you're sued in Pennsylvania all the time, is sort of the idea. You run a lot of shop in Pennsylvania. So Pennsylvania is a place where you can be generally sued. Uh-oh. Uh-oh. right? So this is the idea. It's not that I have the specific injury in Pennsylvania, it's the idea of general jurisdiction. So we're flying directly in the face of United States Supreme Court law over here, right? We want to sue a corporation. We can sue them generally where they live. Where does a corporation live? Well, they live in the place of incorporation or the place in which they primarily do business. For this railroad, that's Virginia. So if we want to sue them for anything, Virginia would be fine. If we want to sue them for a specific thing, perhaps where the specific thing occurred. But now we want to say, no, we want to sue you in Pennsylvania. Not because the specific thing occurred in Pennsylvania. Oh, no, no. But because you are generally located in Pennsylvania. Uh-oh. Because that directly flies in the face of Supreme Court precedent. You can't do that. Or can you? Because we're before the United States Supreme Court. So they're the ones about to decide whether or not this old doctrine remains the law. How exciting. So Norfolk Southern has registered to do business in Pennsylvania in light of its regular, systematic, and extensive operations. Uh-oh, we are directly challenging Supreme Court precedent. We're flying right smack dab in the face of personal jurisdiction precedent over here. Can we sue Norfolk Southern generally in Pennsylvania, despite the fact it's neither incorporated there nor its primary place of business there? The law up to right now would be the answer is no. Does it continue to be no? Pennsylvania requires out of state companies that register to do business in Commonwealth to agree to appear in courts on any cause of action. So he's trying to say that by registering in Pennsylvania, they've agreed, essentially by contract, they've agreed to waive this issue. So sure, you couldn't normally be waived and you couldn't normally be sued in Pennsylvania, but by doing business in Pennsylvania, you have waived that issue. Waiver. Okay. Well, you can see the problem right away, right? If states could require waiver, then every state will require waiver and for every kinds of action, and it will completely defeat this. So if we allow Norfolk Southern to be sued in Pennsylvania because they agreed to a waiver that was imposed on them as an operation of law, you know for an absolute certainty that every single state is going to require every single business to agree to these waivers. So the concept of general jurisdiction when it comes to corporations will come to an absolute and total end, and right quick. So if this is the right answer, it is the end of law as we know it. So, there's that. Okay. By complying with the statutory scheme, the person who's harmed over here submits that Norfolk Southern has consented to suit. If that's true, it's the end of the issue when it comes to general jurisdiction for corporations because they will be generally sued everywhere because every single state will require that they waive it. You know for certainty it will happen. So, do we want to do this? I'm betting the Supreme Court's going to say no. I'm betting the Supreme Court's going to say no. I'm going to say that no, Pennsylvania cannot require them to waive this as a matter of statutory agreement because it would impose an unfair condition in the regulation of interstate commerce. So I'm betting the Supreme Court is going to stand by the precedent and say, no, you can't do this. Let's find out if I'm right. The Pennsylvania Supreme Court sided with Norfolk Southern because the Pennsylvania Supreme Court is bound by the law. And so, sure, the Pennsylvania Supreme Court should side with Norfolk Southern because that is absolutely the correct answer up until right now. So the Pennsylvania Supreme Court came to the right decision under the precedent. Only one place left to go, change the precedent, right? So let's see if we can do that. That court that found that Pennsylvania law requiring the out-of-state firm to answer in the Commonwealth for any suits against it in exchange for status as a registered foreign corporation violates due process. The Pennsylvania Supreme Court is right. Let's find out if it continues to be right. Held. The judgment is vacated and the case remanded. Ooh. Personal jurisdiction looks like it might be changing. Okay, so it looks like we're about to change the law when it comes to corporation. Every corporation's ears perk up like, wait, what now? Wait, what now? What's going on? All right, let's find out. This case is controlled by Pennsylvania Fire versus Gold Issue Mining. Much like the Missouri law that the court in Pennsylvania Fire found, to comport with due process clause, the Pennsylvania law at issue here provides that out-of-state corporations may not do business in the state unless it registers with the Department of State. Ooh, okay, guys. Big changes coming down. Big changes coming down here at Supreme Court land. It's going to hit you like a freight train. It's coming down so hard. Okay. Among other things, Pennsylvania law is explicit that qualifications as a foreign corporation shall permit state courts to exercise general personal jurisdiction over registered foreign corporations, just as they can over domestic corporations. Ooh. Norfolk Southern has complied with this law since 1998 when it registered to do business in Pennsylvania. Norfolk Southern applied for a certificate of authority from Commonwealth, which, once approved, conferred on Norfolk Southern both benefits and burdens shared by domestic corporations, including amenability to suit in state court on any claim. For more than 2 decades, Norfolk Southern has agreed to be found in Pennsylvania and answer any suit there. Holy shit, dude. This feels like one hell of a change in the law. This feels like one hell of a change in the law, because up to this second, the answer for general personal jurisdiction was the state of incorporation and the state of your principal place of business, period. End of analysis. Those 2 places, no other places. And they could be the same place, as I point out. So no more than 2 places. And the U.S. Supreme Court just said, okay, states can waive that by imposing on you as a condition of law. So we went from businesses can only be sued in Delaware. We went from businesses can only be sued in Delaware to suddenly businesses can be sued everywhere. Okay. I mean, sure, that's a pretty big change in the law. That's a pretty big change in the law. So, okay. All right. Pennsylvania Fire held suits premised on these grounds do not defy defendants' due process. Mr. Mallory no longer lives in Pennsylvania, and the cause of action did not accrue there, but none of that makes any difference. Wow. To decide this case, the court need not speculate whether any other statutory scheme and set of facts would establish consent. It's enough to acknowledge the state law and facts before it falls squarely within Pennsylvania Fire. Okay. In proceedings below, the Pennsylvania Supreme Court seemed to recognize Pennsylvania Fire dictated an answer, but ruled for Norfolk Southern because, in its view, intervening decisions had implicitly overruled Pennsylvania Fire. Yeah, the Supreme Court says that's an error. Was it? Was it an error? I guess it was. Because, well, I apparently came to the wrong conclusion along with literally everyone else. Yeah, we all were under the impression that that old law was no longer good law. But apparently it's good law, I guess. As the court has explained, if a precedent of the court has direct application in the case, as Pennsylvania Fire does, a lower court should follow the case which directly controls, leading to this court the prerogative of overruling its own decision. This is true even if the lower court thinks the precedent is in tension with some other lines of decision. Yeah, intention would be one way of describing it. Yeah, vacated and remanded. Okay, okie dokie. Gorsuch announces the judgment of the court in which Thomas, Alito, Sotomayor, and Jackson join. Alito files an opinion concurring apart. Barrett files a dissent in which Roberts, Kagan, and Kavanaugh join. 5-4. Holy shit. Yeah, this is a pretty big deal. This is a pretty big deal. Well, I guess going forward, every single state is going to pass a law requiring every single corporation to consent to general personal jurisdiction. And I guess that's A-okay. So I guess everything I knew was wrong. Okay. Fine. Thus, that brings us to the end of discussion of Mallory versus Norfolk Southern. And holy shit, this is a huge issue. This is a really, really big deal. Personal jurisdiction law just changed in a super major way, in an incredibly major way, in a 5-4 decision. Up until like 5 seconds ago, If you wanted to sue a corporation generally, you could only sue it in the place where it was incorporated and the place of its primary business, which is typically its C suite, where its top executives are. That's typically how you define that. Only those two places generally. Maybe you can sue it specifically over specific things that occurred specifically in other states, but this is not that. This has nothing to do with Pennsylvania. Literally has nothing to do with Pennsylvania. Okay, the injury didn't occur in Pennsylvania. No one's suggesting it occurred in Pennsylvania. Mallory has no ties to Pennsylvania. He briefly lived there, but that has nothing to do with anything. Okay, so this has nothing to do with Pennsylvania at all. But we're going to sue in Pennsylvania. Why? Because the law is slightly more attractive in Pennsylvania than it is in Virginia or Ohio. We could sue in those places, but we don't want to. We want to sue in Pennsylvania because the law is more attractive there. And apparently we can. Apparently we can, because state law can require a corporation to consent to general personal jurisdiction as a condition for doing business in the state. And apparently that's not a problem. So interstate commerce just became a lot more complicated for every single corporation in the face of existence. Holy shit, guys. I'm not sure if I'm selling how big a deal this is. This is a really, really big deal. This is an incredibly big deal. It's a 5-4 decision, and I'm not surprised because this is a major, major modification of the understanding of personal jurisdiction law. And yeah, so there's that. And that for the moment brings us to the end of discussion of this state. Okie dokie. Well, push the button. That turned out interesting. Law professors are gripping Penoyer versus Neff international shoe right now, rocking back and forth. Yeah, that sounds about right, Matthew Harris. Yeah, that sounds about right. Yeah, Penoyer versus Neff international shoe. And also don't forget BMW. Don't forget BMW. Not they yeah, they're clutching on BMW and Penoyer and international shoe and rocking back and forth slowly and be like, but that's not the law. That's not the law. Yeah. Civ Pro is going to be interesting next year for all the law students. It's like, okay, law students, I got to teach you brand new Civ Pro because the Civ Pro just changed in a massive way. Instead of being suable only some of the places, how about literally everywhere? Which is apparently not a problem and doesn't affront due process in any way whatsoever. Wow. Okay, Runkle's stuck in court. No problem. Well, thank you for dropping by, Runkle. Imagine how many professors are rewriting their syllabus right now. Yeah. Yeah, this is yeah. In tension with is one way of describing it. Yeah. Well, I guessed wrong. Okay. It's taking me a full second to process this because of how big it is. Okay, well we started very spicy. This is I know everyone is waiting for like the student loan case or 303 creative dealing with the First Amendment issues. And this case will probably not get any news play. You will not hear about that case on show me a national news program that covers this case. This case is not going to get the flashing banner on CNN, but this is just as huge as that and arguably more huge. But you guys know about it because you guys were here on Uncivil Law, so Okay. Okay. CNN won't understand it. CNN's legal is going to understand it. I'll tell you what. Right now, in every corporation, right now, in every corporation, there is a lawyer panicking. Right now, in every single corporation, CNN and Ford and everywhere. Some right now there are not right now there are 5,000 lawyers sweating profusely. Yeah. Credit card companies is the one that immediately gets my attention, you know, because like all those guys, all those credit card companies are either based in Delaware or South Dakota because the respective laws in Delaware and South Dakota are really good for like the credit card companies. And uh as you would appreciate, credit card companies kind of do business everywhere. And so those protections that they had up until 5 seconds ago from being located in Delaware and South Dakota just vanished. So right now, chief legal for Visa, chief legal for MasterCard, chief legal for Discover, chief legal for American Express are looking longingly at their intoxicant of choice and curled up on a floor somewhere. Yeah. Yeah. What's significant about Delaware law? It's just extremely business friendly. It's just really, really friendly to corporations. The law in Delaware is written in a way to be just very, very, very friendly to corporations. So it is more difficult to sue a corporation in Delaware than most states. The law is more favorable towards corporations. Corporations, all else being equal, are much more likely to win in Delaware than other states because Delaware has very deliberately written its law to be corporation friendly so that corporations will base their corporation in Delaware. So, pretty much every corporation you've heard of, well, has its businesses in Delaware, or a lot of them do, because it's really hard to sue comparatively in Delaware versus other places because Delaware is extremely business friendly. And credit card companies in particular, like it's really friendly in South Dakota. It's just South Dakota has made choices to make its law very friendly to the credit card companies comparatively. So if you're a credit card company, the law, you're looking for a state to base your credit card business in. If you're Visa and you're like, which state should I base my credit card business in? Which state is best state? South Dakota and Delaware are nice candidates for you, right? But those advantages just disappeared. So yeah, great. Yeah. Okay. I'm gonna stop. I'm gonna stop like having a heart attack over here. This this message of hope goes out to Chief Legal Counsel for Visa, MasterCard, Discover, and American Express. Dear Chief Legal Counsel for Visa, MasterCard, Discover, and Express, don't worry, it gets better. One day at a time. Stay strong. You can make it. I believe in you. For today's United States Supreme Court case, we discuss what constitutes an actual true threat. True threats are not protected speech. You can't threaten people because you're imposing on them harm emotionally, psychologically, and also just, behaving in a way that obviously can be prosecuted criminally. But there's a question, or had been a question, about what constitutes a true threat. Is this determined subjectively by the person receiving the threat? So is it in the mind of the recipient whether or not they believe there's a true threat? Is it objective, a reasonable person, whether a reasonable person would perceive the threat? Or is it a combination? Maybe we need both. So, what do we need for it to be a true threat? Is it in the mind of the person threatened? Is it in the mind of a third party observer? Perhaps it's both. What constitutes true threat? Let's get started with this. Scott Pearson is back? Really? Holy shit. Well, he's going to jail. Fuck that guy. Holy shit. They didn't even make it to lunch. What, they've been deliberating 2 hours? Fuck. Has the court announced when the verdict is actually being read? Because we can go over to that for verdict watch. Oh, it's just a jury question? Okay. All right, it's just a jury question. All right, fine. Stop giving me heart attacks. It's not good for my heart. From 2014 to 2016, the petitioner, Billy Counterman, sent hundreds of Facebook messages to CW, a local singer and musician. The two had never met, and CW did not respond. In fact, she tried repeatedly to block him, but each time, Counterman created a new Facebook account and resumed contacting CW. I'm familiar with this fact pattern, unfortunately, as a creator as well. So I understand CW's plight. Several of the messages envisioned violent harm befalling her. Counterman's messages put CW in fear and upended her daily existence. CW stopped walking alone, declined social engagements, and canceled some of her performances. CW eventually contacted the authorities. The state charged Counterman under a Colorado state statute, making it unlawful to repeatedly make any form of communication with another person in a manner that would cause a reasonable person to suffer severe emotional distress and does cause that person to suffer severe emotional distress. Counterman moved to dismiss the charge on First Amendment grounds, arguing that the messages were not true threats and therefore could not form the basis of a criminal prosecution. Following Colorado law, the trial court rejected that argument under an objective standard, finding a reasonable person would consider the messages threatening. So the trial court says, let's look at this objectively. Would a reasonable person, the reasonably prudent person, the ordinary person on the street, in other words, jurors, what do you think? Do you think it's threatening? In your own mind, collectively. Because that's how we determine the objective. We ask the jury collectively what they think. And whatever 12 of them agree on is what the reasonable person would agree on. Because all 12 of them agree on it. So that's how we do that. Great. So they said objective, fine. Counterman appealed, arguing the First Amendment requires the state to show not only the statements are objectively threatening, but also show that he was aware of the threatening character. So now we're going to try to do this from the subjective view of the person making the threats. So we could view this from the subjective view of the person being threatened. We could view this objectively. And there's the third possibility. Maybe we need to look at the subjective mind of the person making the threat. Maybe their intent is relevant or their knowledge or something. We need some sort of knowledge of their own threatening behavior. Maybe that's required. The Colorado Court of Appeals disagreed and affirmed. The Colorado Supreme Court denies. Held, the state must prove in true threat cases the defendant had some subjective understanding of his statement's threatening nature, but the First Amendment requires no more demanding showing than recklessness. So, yes, you have to show that the defendant was at least reckless. You have to show that he at least recklessly disregarded the threatening nature of it. So, yeah, go back to trial and prove it again, which I imagine will not be a problem given the fact pattern, but they have to go back to trial and prove it again. So not only would an objective, really reasonable person view them as threatening, but the person making the threats has to at least be reckless in their charge. So, fine. The First Amendment permits restrictions upon the content of speech in few limited areas. Among these historic and traditional categories of unprotected expression is true threats. True threats are serious expressions conveying a speaker means to commit an act of unlawful violence. The existence of a threat depends not only on mental state of the author, but on what the statement conveys to the person receiving the end. Yet the First Amendment may still demand a subjective mental state requirement shielding some true threats from liability. That is because bans on speech have the potential to chill or deter speech outside the boundaries. An important tool to prevent that outcome is to condition liability on the state's showing of a culpable mental state, which is not particularly surprising, right? It's the mens rea element of the thing. So, yes, in most criminal law, you need to show mens rea. Now, you could show mens rea a couple different ways when it comes to the true threats, right? The knowledge of sending the threats or the intent to send the threats, right? So there's a couple different ways to show mens rea, right? Do you have knowledge or intent to send the messages? But here, the Supreme Court says something a little bit more specific is required. Not only the knowledge or intent to send the message, but also underlying recklessness, that you behaved in a reckless way, in a way that demonstrates true threats. An important tool, okay, that kind of strategic protection features in this court's precedent concerns the most prominent categories of unprotected speech. With regard to defamation, a public figure cannot recover for injuries such that a statement causes unless the speaker acted with knowledge it was false or reckless disregard, as we know all too well, right? So defamation also requires a mens rea element for the speaker. Okay. That same idea arises in law respecting obscenity and incitement to unlawful conduct. The same reasoning counsels in favor of requiring a subjective element in a true threat case. A speaker's fear of mistaking whether a statement is a threat, fear of the legal system getting judgment wrong, and fear of incurring legal costs all may lead a speaker to swallow words that are in fact not true threats. Insistence on a subjective element in unprotected speech cases, no doubt, has a cost, even as it lessens the chill of protected speech and makes prosecution of otherwise prosecutable and often dangerous communication harder. But subjective standard is still required for true threats, lets prosecutions chill too much protected, non-threatening expression. So, this makes logical sense. The threat not only has to be objectively threatening, so we need now three different things, right? It needs to be subjectively threatening to the person receiving the speech. Otherwise, they don't have a problem with it, right? So if they don't perceive it as threatening, then I guess it's not a problem because it doesn't cause them any harm, right? So subjective fear or subjective perception on the part of the recipient. It has to be objectively threatening. So a reasonably prudent observer, the reasonable man on the street would perceive it as threatening, but also one step more. We have to go to the subjective mental state of the person making the threats to see that they are at least behaving in a reckless way, which, given this fact pattern, I don't think will be too hard. Given the fact that they were blocked multiple different times, given the fact that they continued to block the accounts and the person continued repeatedly, despite being blocked over and over again, despite being told that they were not welcome, despite being blocked, just created new accounts over and over and over and over and over again. Yeah, that they are behaving in a way that's reckless because, hey, all those blocks are providing knowledge to the person that they're behaving in a way that is causing distress. And then now they have that awareness, or they should have that awareness. So that conscious disregard by creating new accounts over and over and over again, that is creating harm to the person, is showing recklessness. So under this fact pattern, I don't think demonstrating recklessness is going to be very difficult because it happened over and over and over again. So I think the state will be able to prove its case. Shouldn't be too much a problem. In this context, the recklessness standard, the showing of person, consciously disregard a substantial and unjustified risk the conduct will cause harm to another is an appropriate mens rea. Requiring purpose or knowledge would make it harder for states to counter true threats, with diminished returns for professional inspection. So we don't have to show intent to communicate. So it is not required to show the person intended to communicate a threat. That is not required. We don't have to show they intended to communicate the threat. We don't have to show that they acknowledge that it was threatening. We just have to show reckless disregard. Reckless disregard. How would we demonstrate reckless disregard? Well, in a case like this, we would demonstrate reckless disregard because they kept getting banned over and over and over and over and over. And the person just kept creating account after account after account to try to get around and continue to harass this person continuously. So, should be easy to show that they knowingly disregard, consciously disregard, that their messages were unwelcomed and causing harm. So, shouldn't be too difficult to prove in a case like this, one would imagine. Using recklessness standard also fits with the court's defamation decisions, which adopted recklessness more than a half century ago. The court sees no reason to offer greater insulation to threats than defamation. While this court's incitement decisions demand more, the reason for that demand, the need to protect from legal sanction, political advocacies, a hairbreadth away from incitement, is not present here. So, in the case of incitement, we do require more. Why? Because it's political speech, right? It's often political speech, right? It's often speech directed at the government. Like, government sucks. We hate the government. Down with the government, right? So the problem is, in the case of that, we are in a political speech, and in the First Amendment arena, political speech often gets a higher level of protection because it is the core of the First Amendment context. The entire point of the First Amendment at its core is to speak about the government, right? Because it's the government making things illegal. It's the government that's incentivized to make things illegal. So when we are making speech about the government, the political speech, we require more because we don't want people to be dissuaded in their political speech because it goes to the core of the First Amendment protection. But when it's not political speech, when it's not rooted at what the government is doing, we don't require as much because political speech gains more protection than non political speech because political speech is at the apex of what the First Amendment is designed to do. For true threats, recklessness strikes the right balance of offering enough breathing space for protected speech without sacrificing too many of the benefits of enforcing laws against true threats. The state prosecuted countermen in accordance with objective standards and did not have to show any awareness of threatening character. That's a violation of the First Amendment. So back to trial for you, which I imagine will not be too much of a difficulty because proving recklessness should be pretty trivial, right? By showing that he obviously had knowledge of all these bans because he keeps creating accounts over and over and over and over and over and over and over again to get around the bans, obviously is consciously disregarding that the creator doesn't want the speech and the creator is creating harm. So now all you have to do is prove the objective reasonableness and prove the subjective feelings of the creator, and you're there. So maybe if you keep getting banned all the time, it's a clue that they don't want you to talk to them. Leave them alone. Kagan delivers the opinion of the court in which Roberts, Alito, Kavanaugh, and Jackson join. Sotomayor concurs. Gorsuch concurs. Thomas dissents along with Barrett in a 7-2 fractured decision. Thus, that brings us to the end of coverage of the case of Counterman versus Colorado. In this case, Counterman kept creating accounts on Facebook to continue to try to message a creator, and the creator kept banning them, and they kept trying to create new accounts over and over and over again, persistently. And they kept doing it for long periods of time and kept doing it to the point it created harm in the mind of the creator. And now there is a problem because we have true threats. So this case has to go back to trial to prove that Counterman was reckless in his behavior because we've previously proved the objective standard because the jury convicted, and we've previously proved harm to the creator because the subjective standard, but we didn't prove the creator was reckless. But it shouldn't be that hard because we have all this evidence of all them attempting to continue to contact the person despite their repeated bans. So, yes, we have to prove the subjective element. Shouldn't be that difficult in this case. And that brings us to the end of discussion of this case. Exciting. Hmm. Push the button. Thank you. Yeah. Kestrel gets a prize for reminding Uncivil to push the button. See, this is what happens when I stay up all night with you, and I just generally forget to push the button. I'm not very good at remembering to push the button, so it's nice for the chat to remind me. All right, let's do another one. Says, what happens when demonstrative conflicts with the evidence? Well, that shouldn't happen. They do have to agree to the demonstratives. You can object to a demonstrative too. So there shouldn't be a conflict between the demonstrative and the evidence. But they're still only offered for demonstrative purposes, not for evidence. So, although I am a little tired. I'm tired a lot. Tiredness and I. Yeah, I'm tired a lot. Despite the CPAP, I'm still tired a lot. Eh, I am a bit sleepy. I'm perpetually a bit sleepy. I don't. I'm always tired. I'm perpetually tired. It doesn't matter how much I sleep. I'm always tired. Have I done a sleep study? Yes, I've done a sleep study at least twice. Hence the CPAP. Yes, I had improv last night, and I have improv again today. When did I start the CPAP? About 6 years ago. New sleep study? Well, what would a new sleep study tell me that I don't already know? That's the question. What would a new sleep study tell me that I don't already know? I'm assuming that the condition didn't get better since then, so what would be the point of a new sleep study? It would be my question. Yeah. Have I found improv classes to be helpful with my videos? Mm, I don't know the degree to which it's helpful or not, but it's a nice skill set to learn. I figure the one's got to run on the other. So, can I consciously illustrate how improv has been helpful towards my YouTube videos? I'm not sure I could make a conscious connection, but I've got to believe that the connection between the two. Yeah, new CPAP machine is what I meant. Well, the one I have is pretty good. It's the ResMed. It's like it's only one generation old, and it seems to work perfectly fine. I don't think there's a problem with the machine itself. It's only one generation old. I don't think the new machine is like fundamentally better like than the old machine. So I really doubt it's the machine that's the problem. Um, I doubt there's enough difference between the version 10 and version 11 or whatever it is. I do blood work too. I do blood work too for various therapies I'm on. I do blood work quarterly. So I do blood work and I've done the sleep studies. My blood work incidentally is really, really good. Uh, is so except for one thing that I supplement. But other than that, yeah, my blood work's actually really, really good. So which is nice, despite being a fat ass that, my like cholesterol and stuff is really good. So my weight has yet to catch up with me on my blood work, which is nice. So that's plus. Is it self-adjusting? As a matter of fact, yes, it is. It is self-adjusting. The CPAP, yes, it does self-adjust. It's a nice one. It's a nice CPAP. Yeah. As the owner of the ResMed 11, I seriously doubt it's all that more effective than 10. Yeah. I think the 10 can kind of do everything. It does everything. I'm not sure what the difference is between the 10 and 11. You know, no restless leg syndrome, no. I used to take medicinal, but I haven't had a prescription in a while. Medicinal helps me not be so tired all the time. But the insurance companies hate paying for it because it's so expensive. So maybe it's time for me to fight for my insurance company again and get back on medicinal, which is also known as Provigil, which is also incidentally the drug that the movie Limitless was based off of, or the TV show. I have to say that it did not quite provide that effects in my life. It didn't quite make me uber genius, who was able to, just understand all information and just be the smartest person ever on the face of the earth and make me super charismatic and charming. So, the movie Limitless somewhat lied to you about the effects of medicinal and Provigil. It's not that good. Yeah, the doctor definitely said that my weight may be tied to the CPAP issues. He's like, yeah, my doctor, when they diagnosed me, made a point of noting that often sleep apnea is correlated with weight. So there are definitely some thin people who have sleep apnea, but weight can be a significant contributing factor to uh, to sleep apnea. And he suggested that losing weight would be a good thing to do. And that was like several years ago. So the struggle continues. Yeah, that's enough of my personal problems. I love how we've turned into medical diagnosis over here right on civil law. That's fun. Well, my neck is definitely well above 17. Probably more like 19. Come lose weight in Hawaii? You paying? All right. For today's United States Supreme Court case, we turn our attention to another redistricting case in the case of Moore versus Harper, which deals with issues of redistricting and also deals with the question of who can raise those complaints to the United States Supreme Court. Can the Speaker of the House of Representatives bring the complaint, or does it have to be some executive branch official? What is the role of the House of Representatives in raising these issues? So let's go ahead and get started with this. Vyvanse, I had Vyvanse. Um, I liked Vyvanse very much. Um, but my doctor wouldn't prescribe it. My last doctor wouldn't prescribe it. I had Vyvanse once, and then I switched doctors, and my last doctor wouldn't prescribe it. Um, and I haven't seen another doctor since then because I was so discouraged from the appointment. I was so discouraged. I went there and I was like, I want you to prescribe these things. And my doctor's like, no. I'm like, okay, well, I guess I'm never seeing you again. And now I've been discouraged from finding another doctor. Finding a doctor is hard. Finding a doctor who'll give you what you want is even harder. But yeah, Vyvanse is one drug I've had success with, but I can't get it prescribed. Do any of you guys, are any of you guys a doctor? Can you prescribe me Vyvanse? Let me know. I could use an MD right about now. Do any of you guys have a prescription pad? Let me know. I can't use cannabis. Cannabis is illegal in Texas. The election clause of the federal constitution requires the legislature of each state to prescribe the rules governing federal elections. This case concerns the claim that the clause vests state legislatures with the authority to set rules governing federal elections free from restrictions imposed under state law. So this is the idea of only the state legislature can prescribe the rules dealing with election. There's no role for the state judiciary, no rule for the state executive. Under federal law, only the legislature can act. So this is this independent state legislature doctrine, deeply controversial idea. I don't think the Supreme Court's going to go for it, but this is the idea, right? The Constitution says the legislature of each state prescribes the rules, and their argument was literally only the legislature, no role for state executive, no role for state judiciary, literally only the legislature. The legislature gets to act alone, independent state legislature. So this was one of these theories that had been percolating around in some of the more conservative circles, but not an idea that I ever prescribed to. It didn't make sense to me. But some of the hardcore right people really like this idea. I'm not sure they should, incidentally, because that would mean that legislatures that would be opposed to them would be able to do whatever the hell they want. But I digress. Following the 2020 census, North Carolina's General Assembly drafted a new federal congressional map with several groups of plaintiffs challenging the map as an impermissible gerrymander. The trial court found the partisan gerrymandering claims non-judiciable under the state constitution, but the North Carolina Supreme Court reversed. So the trial court says, I can't review this. And the state Supreme Court's like, yes, you can. You can review whether this is improperly gerrymandered. But now it's the state Supreme Court issuing a decision that says, yeah, you can do this, but can you? Because under federal law, maybe it's the legislature acting alone, and there's no role for the North Carolina Supreme Court. That has been the argument. Okay. While acknowledging that partisan gerrymandering claims are outside the reach of federal courts, the state Supreme Court held that such questions were not beyond the reach of the North Carolina courts. So partisan gerrymandering is been said there's no judiciable standard to say whether or not it's been gerrymandered as a matter of federal law. And the states are like, well, we'll give it a try and say maybe we can say as a matter of our state law that we can judiciate it as a matter of our state law, but maybe there's no role for the state government to play here. The court also rejected the argument that the federal elections clause vests executive and independent authority in the state legislature to draw federal maps. So this is that independent state legislature doctrine. Only the state legislature, literally only them. In this context, the legislature is the executive and judicial branch all rolled up into one. So in this context, the state legislature would be king because they'd be all three branches brought together. And only the federal government would have any power over them. And the federal government's already declined to review this issue. So there'd be nothing for the state to do. The court enjoined the use of the maps and remanded the case to trial matter for remedial proceedings because the North Carolina Supreme Court's like, we have power. The legislature then filed an emergency application in this court, citing the election clause and requesting a stay. The court declined to stay, but later granted cert. So we will take a look at whether the North Carolina Supreme Court has any power here as it relates to state law. After this court grants cert, the North Carolina Supreme Court issued a decision addressing a remedial map adopted by the trial court. So the trial court was still, the North Carolina legislature was still, churning along because there had been no injunction issued by the U.S. Supreme Court. So there had been no stay, right? So yes, it got appealed to the U.S. Supreme Court, but there was no stay. So the North Carolina courts are like, okay, we're just going to keep churning along. So continuing to churn along, the North Carolina Supreme Court validated a map that was drawn by the state trial court because the thing was still proceeding. North Carolina Supreme Court then granted the legislative defendant's request to rehear that decision. The court ultimately withdrew the opinion, concerned that the remedial maps and overruling a different case, repudiating its holding that partisan gerrymandering claims are justiciable. The court dismissed the plaintiff's claim but did not reinstate the 2021 map struck down. This court has entertained 2 rounds of supplemental briefing on jurisdictional questions in the light of state court rehearing. So can a state court hear this kind of case? Okay. Doctor shopping sucks ass. I don't like it very much because it takes forever to get an appointment. It takes 4 months to get an appointment with a new doctor and then just to be disappointed again. And it's like, then I start wondering why I'm paying for health insurance at all. Aren't checks and balances a thing? I'm confused. Then I have failed. I have failed as an educator, and I'm sorry. I have failed. I'll try again. Under the federal constitution, there is language that says the legislature of each state prescribes the rules governing federal elections. So if it is literally the legislature that prescribes the rules governing for federal elections, then if that's one way of interpreting that would mean there's no role for the state courts or the state executive for that matter. Because if it's literally the legislature of the state and only the legislature of the state, there's no role for the state executive and no role for the state judiciary. So in this context, the legislature would be legislative, executive, and judicial all rolled up into one. They would be king. It would be what we call in law a plenary authority. It is only the legislature, and there is no review beyond that. So hopefully that answers your question. That's the argument. Yeah, 4 months. It takes 4 months to find a doctor with an appointment. It's yeah. Welcome to American healthcare sometimes. Did I explain it better? Evalistrif, did I explain it better? Did I succeed as a teacher? I try. Did I succeed or do I need to try again? I'm waiting. Okay, great. Held, this court has jurisdiction to review the judgment of the North Carolina Supreme Court that adjudicated the federal election clause issue. So there is a constitutional provision for the Supreme Court to review, so fine. A corollary to this court's jurisdiction over cases and controversies is there must exist a dispute at all stages of review, not merely at the time the complaint is filed. The North Carolina Supreme Court decision to withdraw a decision and overrule a different decision does not moot this case. So the Supreme Court of the United States believes there's still a live controversy despite what the North Carolina Supreme Court decided to do. Okay. Prior to appeal and rehearing proceedings, the court had already entered judgment and issued a mandate, and the legislator defendants acknowledged they would remain bound by the decision in joining the use of the plans. When the North Carolina Supreme Court overruled its decision as part of the rehearing process, it repudiated the conclusion that partisan gerrymandering claims are justiciable under North Carolina Constitution, but the court did not purport to alter or amend the judgment in joining the use of the map. So the Supreme Court of the state said, we don't have power to review this, but didn't change the decision that they used. So they previously said, we had power to change it and then changed it, and then said, we don't have power, but didn't change it back. So the map still exists, despite the fact that they didn't have power to change it. So the judgment still exists despite the lack of underlying power. So the Supreme Court can adjudicate the map. Okay. Were this court to reverse some decision, the 2021 plans would again take effect. Because the legislature defendant's path to complete relief runs through this court, the parties continue to have a stake. Okay, so we've satisfied the standing problem and say, yes, they're still standing because the North Carolina Supreme Court repudiated its own power, but didn't repudiate the decision that it decided based on the power that is now repudiated. So the decision still stands despite the fact it says it doesn't have power. So we need to adjudicate the map. Okay. The court also has jurisdiction to review the judgment under a different law, which provides jurisdiction in this court extends to final judgments rendered by the highest court of a state. Fair enough. Because subsequent proceedings have neither altered the analysis of the federal issue nor negated the effect, the issue has survived. Yes, they're still standing. Okay. To the merits, the election clause does not vest exclusive and independent authority in the state legislature. So, yeah, all the people who are uber panicked about the hard right, in this independent state legislature doctrine can relax. And the North Carolina Supreme Court can presumably reverse itself again. The North Carolina Supreme Court almost certainly reversed itself because it didn't want the Supreme Court to review it, but didn't go all the way. So now that they've gotten all clear, I expect the North Carolina Supreme Court will reverse itself. So we were wrong. No, we were right. So, now that we've got power. Okay, so the elections clause does not vest exclusive authority in the state legislature. So this independent state legislature doctrine is a non-starter. Marbury versus Madison famously proclaimed this court's authority to invalidate the laws that violate the federal constitution. But Marbury did not invent the concept of judicial review. State courts had already begun to impose restraints on state legislatures even before the Constitutional Convention, and the practice continued to mature during the founding era. James Madison extolled judicial review as one of the key virtues of a constitutional system, and the concept of judicial review was so entrenched by the time the court decided Marbury that Chief Justice Marshall referred to it as one of society's fundamental principles. Yes, in contra to Nick Rekieta, I believe that Marbury versus Madison was correctly decided. So we do have a split of opinion among the law tubes. And I believe Nick Rekieta is not alone on this. I don't remember who else is with him. But I believe there is a split of opinion in the law tubes as to Marbury versus Madison. I believe Marbury versus Madison was correctly decided. But, you can talk to Nick Rekieta about that, and he will happily rant about it, I am sure. The elections clause does not carve out an exception to this fundamental principle. When the state legislature prescribes rules concerning federal elections, they remain subject to the ordinary exercise of state judicial review. So, yes, state legislatures can still be reviewed by state courts. In Ohio, ex rel. Davis versus Hyberdent, this court examined the elections clause application to provisions of Ohio Constitution that permitted the state voters to reject by popular vote any law enacted by the state General Assembly. This court upheld the Ohio State Court determination. The federal elections clause did not preclude subjecting legislative acts under the clause to a popular referendum, rejecting the contention that to include the referendum within the state legislative power for the purpose of apportionment is repugnant to the elections clause. So, yes, the voters can also directly vote on this issue and exercise legislative authority themselves. So, to the extent that the state allows for state voters to do things by petition, which is often a thing in California, for example, and in this case, Ohio, to the extent that the law allows for voters to create law themselves, they are, in that moment, the legislature. So, yes, the legislature continues to exist in the Capitol building, but the people, being sovereign fundamentally, can yerk that power back and be like, no, we're the legislature now, screw you. And that works as far as the Supreme Court is concerned, no problem. And in Smiley versus Holm, this court considered the effect of a governor's veto pursuant to authority under the state constitution of congressional redistricting. The court held that the governor's veto did not violate the elections clause, reasoning the state's legislature execute of authority under the election clause must be in accordance with the method the state has prescribed for legislative enactments. So no, the legislature doesn't get to just poof this law into existence. The Constitution of the state says this kind of law, like kind of other laws, has to be signed off by the governor. I suppose it doesn't have to say that. There could be some exception in the state constitution because states can kind of do whatever the hell they want. So they could give unilateral power to the state legislature to just do this by joint resolution and call it a day. Well, technically, it would be a concurrent resolution, not a joint resolution, as I correct myself, because technically a joint resolution would have to be signed off by the governor. That's the difference between a concurrent resolution and a joint resolution, as I law geek my ass off over here. So we can't just do it by concurrent resolution and just magic it into existence. It does have to be signed off by the governor because our state constitution requires it, and that's fine by the US Supreme Court. This court recently reinforced it. I need to lose 150 pounds. And it's really hard. It's really hard. And I just want to say, I know this is off topic, but I just want to say to everyone who's there, it does mean a lot to me when you guys encourage me in my workouts and you support me and say, way to go. Because, and I'm struggling. I'm struggling. I am very obese. And although it hasn't shown up on my blood work, thank God, it undoubtedly impacts my health. I can't move around the way I used to be able to move around. I can't do like plyometric exercise, like any sort of running, any sort of plyo, push-ups, any sort of thing where I have to like get to the ground is just like a non-starter because I'm so overweight. And I'm trying so desperately to try to fix the problem. And I've tried that to some degree through cooking and eating out less. And I've tried to some degree to fix this through my exercise. And I know it's not perfect. I know it's not ideal, but I'm trying. I'm trying and I'm trying to make progress. And it's really hard. And it's a struggle. And I really appreciate all the people who support me as I'm making progress and try to support me where I am in my journey and just try to support me that little bit more. Just try to encourage me that little bit more. It means a lot to me. It means a lot to me. It's one of the reasons also I get defensive, really defensive sometimes when you guys collectively try to provide suggestions for like my workout or try to provide suggestions for my eating because I'm trying so hard and I know that some of you guys are coming from a good place and are trying to help things, but it's very, very frustrating sometimes because it's like sometimes the way it's expressed is like if it's not perfect, it doesn't work. Like, there's no I've seen people comment on my workout streams, for example. People say, like, there's no point if you don't get your diet under control. I'm like, do you really literally mean that? Do you really mean there's no point in me exercising if I don't get my diet under control? because, I could very easily believe that, by the way, and then I just give up. Um, so I really appreciate the people who are supportive and encouraging and trying to support me as I try to make progress. So, yeah, I really appreciate all the people who support me. It's hard. And I hate my body image. I hate the way I look. I hate the way that I look. I hate being as fat as I do. I hate my appearance. I feel like such a slob. And that self-hatred can really get to you too, cuz that can be very negative reinforcing, the voices in your head, discourage you, you know, as you feel worthless. So you guys try to help overcome the negative voices in my head. This court recently reinforced the teachings of the case law in cases concerning the constitutionality of Arizona ballot initiatives to amend the state constitution and invest redistricting authority in an independent commission. So, Arizona also has a process to take things out of the legislative hand by direct vote action, direct democracy. And the voters are like, we don't like the state legislature because they suck. We want to make it independent. And the Supreme Court's like, yeah, you can do that too. I know that the state legislature is in the building over there and all, but at the moment, the people are the legislature, so screw you guys because the people are fundamentally sovereign. The people outrule your ass. So, yeah, you're the legislature, but not for the moment. Sucks to be you because the people are voting. Significantly, for present purposes, the court embraced a core principle espoused in different law. Whatever authority is responsible for redistricting, the entity remains subject to constraints set forth in the state constitution. The court dismissed the argument that the elections clause divests state constitutions of power to enforce checks and balances against the exercise of legislative power. So, yep, if the people want to directly vote and they want to be the legislature and they want to enact laws, then, and the state constitution says that's cool and they do that, then, sorry about, being elected and all, but you have no power right now because the people have yanked it away from your asses and you can't go bitching. But federal elections clause, though, Supreme Court's not here for that. The basic principles of these cases reflected in the unanimous command that the state legislature may not create congressional districts independent of requirements imposed by a state constitution with respect to enactment of laws commands that respect. So, no. The precedents of this court have long rejected the view that legislative action under elections clause is purely federal in character, governed only by restraints in the federal constitution. So this clause gives power to the state legislature. But that doesn't mean that the power is purely federal in its nature. And there's no role for the states here. The states have the authority to create this through the legislature, whatever that means to you, state. What is the legislature? It's up to you to decide what the legislature is, right? So if you say the legislature is these body in the state capital, then great. If you say the legislature is us, the voters, then great. And if you say by the state constitution, those enactments are reviewable by your Supreme Court, then great. Great. You're doing the republic democracy thing. You have created a government that it works for us. We see no problem with this. So yeah, there is state power here. The argument to the contrary does not account for the framers' understanding that when legislatures make laws, they're bound by the provisions of the very documents that give them life. Yeah, there is no state legislature, but for the state constitution that makes it so. The state legislature does not exist, but for the state constitution that makes it so. So, The state constitution says, hey, there's a legislature, but it has other words, right? It has other words about, an executive and a judicial branch, and sometimes has some words about the voters and the people and direct referendum. So, yeah, a legislature, we're really thrilled that you exist and all, but you can't just be like, hey, we're here and we have unlimited power, because the very document that says you get to exist also constrains you. So, with the bitter comes the sweet, with the good comes the bad deal. Thus, when a state legislature carries out its federal constitutional power to prescribe rules, it acts both as a lawmaking body created and bound by its state constitution, as an entity assigned authority by the Constitution. Both constraints exist. So, yes, the legislature has to do this. But yes, you're bound by state law. Deal. The court's decision in a different case, which the court analyzed under the Constitution, similarly worded election clause, is not applicable. That decision does not address any conflict between state constitutional provisions and the state legislature. So, yes, there is some law that deals with the electors and how electors get appointed and when electors act. So, electors voting in the electoral college. Hey, there's something, right? The electors vote for the president. Okay, great. So we have some case law dealing with the electors, as one would expect. And that case law dealing with the electors is super interesting and all, but doesn't have very much to do with this clause of the Constitution. So go away. That decision did not address any conflicts between the state constitution and the state legislature, nor does a different case, which involved a contested vote by a state legislature to ratify a constitutional amendment, help the petitioners. That case concerns the power of the state legislature to ratify amendments to the Constitution, which is yet a different clause of the Constitution. Hey, should we have a federal constitutional amendment? Here's a process for going about doing that. Here's how you do that. Well, geez, what does that mean? Let's go interpret that. Well, whatever that means doesn't have a lot to do with this. But fashioning regulations governing federal elections unquestionably calls for the exercise of lawmaking authority, and the exercise of that authority is subject to ordinary constraints. So what is the lawmaking authority? Is it that building in your state capitol? Is it the people? Is it something else? Is it that independent commission you created? Right? That independent commission you created, they're the legislature now. Right? We still have the building in the state capitol. They're cool and all, but they are not the legislature, says Arizona. Arizona said that building in their state capitol is the legislature most of the time, but not for the purpose of drawing district maps. Hey, legislature in the state capitol, you are not the legislature anymore. These guys are now the legislature. You can't do that. We're the legislature. Supreme Court's like, yes, they can. Yes, they can. Now they have two legislatures. They have two legislatures. They have a legislature for this purpose and they have a legislature for this purpose. They can have as many legislatures as they want. They can have a whole group of legislatures, each one of which only has power over certain things. They can do it any way they want. Screw you guys. Petitioners can see that at least some of the state constitutional provisions can restrain a state legislature's exercise of authority under election clause, but they read the case law to differentiate between procedural and substantive. But neither case draws such a distinction, and petitioners do not in any event offer a defensible line. So they're like, okay, the case law speaks to procedural, not substance. And the Supreme Court's like, well, no. And also, you don't differentiate it. So, no. Is there a difference between procedural and substance? Yes. Did you figure out what it is? No. So go away. Historical bound by state constitutional restraints. Two state constitutional provisions adopted shortly after the founding expressly constrain state legislative action. So, the states, when the Constitution was brand new, were still doing this. So that's at least somewhat informative as to what the founders might have had in mind. In addition, mobile state constitutions at the time of the founding regulated the manner of federal elections by requiring that elections shall be by ballot. We could do elections some other way. I mean, we don't have to do elections by ballot. We could do elections by some other way, but we thought, what if people voted? That seems like a good way of doing it. What if when they voted on these like pieces of paper or something, and we counted the pieces of paper? That'd be cool, but we don't have to do it that way. We don't have to, but we did. So let's count the pieces of paper. That sounds fun. Moreover, the Articles of Confederation from which the framers borrowed provide that delegates shall be annually appointed in such matters the legislature of each state to direct. The fact that the Supreme Court is citing the Articles of Confederation is kind of hilarious. I'm not sure when the last time the US Supreme Court cited the Articles of Confederation is, but it's got to have been a hot minute. The US Supreme Court has done some really interesting things with citations recently. The US Supreme Court recently cited Magna Carta, which isn't unheard of, but is pretty rare. And now they're citing the Articles of Confederation? Holy shit. When was the last time the United States Supreme Court cited Articles of Confederation as authority? Holy God. Every sovereign citizen out there just got a little bit of a boost in their life because this US Supreme Court just cited to the Articles of Confederation. I look forward to the sovereign citizens citing this case as propositions that the Articles of Confederation is still good law. Does the US Supreme Court understand what it just did? Does the US Supreme Court understand with this, wow, this is going to work with the sovereign citizens? Oh my God. When's the last time that they cited the Articles of Confederation? Holy shit. Fine. Although the Elections Clause does not exempt state legislatures from ordinary constraints imposed by the state law, federal courts must not abandon their duty to exercise judicial review. This court has an obligation to ensure state courts' interpretation of state law do not evade federal law. For example, states may not sidestep the taking clause by disavowing traditional property interest. Yeah, so we said that, when you take property, you have to provide just compensation. And the Supreme Court actually had to deal with the hypothetical, hey, what if a state says this just isn't property anymore? So we only have to pay just compensation if it's property, but what if it's not property anymore? Then we don't have to pay just compensation, right? Because it's not property. U.S. Supreme Court's on to you, sir. You can't do that. You can't just abrogate the property out of existence so that you don't have to pay just compensation. No. States' courts may not transgress ordinary boundaries of judicial review, such as they aggregate to themselves power vested in the state legislature. Court not need to decide whether the North Carolina Supreme Court strayed beyond the limits as petitioners not meanly preserved. Roberts delivers the opinion of the court in which Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson join. Kavanaugh concurs. Thomas dissents, in which Gorsuch and Alito join. In a 6-3 opinion. Excuse me. Thus, that brings us to the end of the coverage of the case of Moore versus Harper, a case that the left was really concerned about, and you might have heard in the news because of this independent state legislature doctrine. It definitely got some news reports along the way, so I wouldn't be surprised if you had heard about it because there were a lot of people concerned the Supreme Court was going to go full independent state legislature doctrine, but I didn't think they would, and they didn't. They decided that, yeah, the state legislature is still bound by its own state constitution, including its facts about how it does stuff. So the North Carolina Supreme Court probably going to unrepudiate itself in the very near future because it only repudiated itself to get around the United States Supreme Court, but it didn't do it all the way. So it will probably unrepudiate itself and go back to what it was. And I imagine other courts will look to perhaps deal with political gerrymandering on a state level. So that would be something that states could do, perhaps through petition. And some states might do that to end political gerrymandering and put that as part of their state constitution. So apparently you can do that now, or at least the U.S. Supreme Court hasn't said you can't. So, yes, the state legislature is the body to create maps, but what the legislature is up for the people to decide and is bound by the state constitution. And the federal elections clause does not change that. And that, for the moment, brings us to the end of discussion of this case. I still have 4 Supreme Court decisions to go. I'm tired. Then I have to edit these decisions. I don't like being a YouTube creator. All right. Okay. Okay. Push the button. Thank you. Yeah. For today's United States Supreme Court case, we turn our attention to when a co defendant's confession can be used against you as it relates to the confrontation clause. So, as will surprise absolutely no one, many crimes are committed by multiple different people, potentially involved in a conspiracy with one another. And the multiple different people are brought to prison and brought to trial and brought to all the bearers that will have the law enforcement after them. But what if one of the people cops a deal, right? One of them cops a deal and confesses to the crime, right? Says, yes, I did it. It was me. I did it. I was part of the conspiracy. I want to go to prison now, please, very, very much. All right. So this person has confessed. They've confessed to their own responsibility, but they've also confessed in a way that implicates someone else, right? They're part of a conspiracy. So they're saying someone else is also guilty by necessity. So the question is, how can we use this confession, the allocution in open court, mind you? How can we use this, if at all, in the trial of another person? Can we use this confession against the other person? Or do we have to present some other thing because of the confrontation clause? What is required when it comes to using a confession of another Confederate as it relates to confrontation clause concerns? Let's get started with this. Petitioner Adam Samia, along with Joseph Hunter and Carl Siltwell, were arrested by the DEA and charged with murder for hire of Catherine Lee. Okay, please don't commit the murder for hire. Murder for hire is bad. Conspiracy for murder for hire is illegal. Please don't do the conspiracies for the murder for hire. It is a bad thing to do. The government tried all 3 defendants jointly in the Southern District of New York. Prior to trial, the government moved to admit Stillwell's post arrest confession, in which he admitted that he had been in the van in which Lee was killed, but claimed that Samia had shot Lee. So, yes, one of them confessed. One of them said, yes, it was me. I was there, but I didn't shoot the guy. Someone else shot the guy. Since Stillwell will not be testifying on his own behalf, and the full confession implicates Samia, the government proposed the confession be introduced through the testimony of a DEA agent who would testify to the content of the confession in a way that eliminated Samia's name while avoiding any obvious indications of redaction. The district court granted the government's motion with additional alterations to conform to its understanding. So what we'd like to do is one of the guys testified. Well, one of the guys confessed. Okay, he was brought before the government. He was brought to the jail, and they said, "You have the right to remain silent." And he said, "No, I wouldn't like the right to remain silent. The right to remain silent is bad. I'd like to talk to you about all the things." Okay, what would you like to tell us? Yeah, I was totally there. I totally did it. But it wasn't me who shot the guy. I was there, though. It was me. I did the things. It was me. I was responsible. Okay, so now it's trial time. Now it's trial time. So Guy who so earlier was so willing to talk to the police, seems to be somewhat unwilling to take the stand in his own defense. So this guy over here, not thrilled about taking the stand and telling the jury what he earlier told the police so willingly. All right. So the police would like to use his confession against him, as one does. But remind you that all of them are being held jointly. They're being tried jointly, right? So this deals with the confrontation clause because this guy confessed to himself, fine, but also implicates his co-defendants who are sitting right next to him, right? Now we can't force him to the stand because, the right against remaining silent, and this guy apparently would like to remain silent now. So this other co-defendant can't confront his co-defendant because right to remain silent, and this confession is being used. So how do we deal with this problem? The district court says, okay, here's what we're going to do. Okay, DEA, you can bring in this confession against the guy, but you have to eliminate from your testimony any mention of the other people's names, and you have to eliminate from your testimony other things that would identify them. So yes, you can bring in their testimony. Yes, you can say he confessed. Yes, you can say he confessed to being in a conspiracy, but leave out the names. Leave out the names. We don't know who they're in a conspiracy with as he sits at the defense table with the other people. Could be anybody, right? And we'll trust the jury draws the right conclusion. Okay. So at trial, the government's theory of the case was that Hunter had hired Samia and Stillwell to pose as real estate buyers and visit properties with Lee, and that Samia, Stillwell, and Lee were in a van driven by Stillwell when Samia shot Lee. So they want to kill this woman. She's a real estate agent. So how do we get her? We'll pose as buyers. We'll pose as buyers for the real estate. The three of us will pose as buyers, and we'll convince her to please enter our van so we can discuss privately, this deal we want to do, because the van will be a nice place where it'll be secluded from others. And then, we shoot you. And then that's the murder for hire. So that's what we did, apparently. Okay. As the government's case in chief, the DEA testified that Stillwell had confessed to a time when the other person he was with pulled the trigger on the woman in the van that he and Stillwell was driving. So who is this mysterious other person, right? There are three of them on trial. Okay, there are three of them on trial. He's one of them. There's one of them that's driving the vehicle, and a mysterious unnamed third person. Also, there are three people at the defense table. Him, the other guy, and a third guy. Who is this mysterious third person? We have no idea who it could possibly be. It could be anybody. We know that he was in the van. We know that the other guy's in the driver's seat. Who's the mysterious third person who pulled the trigger? Could be literally anybody. We didn't mention their name. Okie dokie. Other portions of the testimony recounting the confession use the other person descriptor to refer to somebody, just anybody, whom Stillwell had traveled with and lived with and carried a particular firearm. Both before the agent's testimony and again prior to deliberations, district court instructed the jury the agent's testimony about Stillwell's confession was admissible only as to Stillwell. Hey, jury, this confession that Stillwell gave, only for him, okay? Don't consider the confession that Stillwell gave against any other person, particularly unnamed people who may or may not in any way be related to people sitting at the defense table, okay? Don't consider it for any other purpose, just this purpose, okay? All right. And should not be considered against Samia or Hunter. Please don't consider the confession that clearly implicates some random person against anyone who may or may not be sitting at the defense table. Samia and his co-defendants were convicted of all counts. They did the murder for hire. On appeal, Samia argues that the omission of the confession was error because other evidence and statements at trial enabled the jury to immediately infer the other person described at the confession was himself. Well, there is some suggestion that a reasonable person might draw that inference, right? There are three people who were involved in this murder, according to the confession. We named two of them, okay? We named two of them. Those two people are currently sitting at the defense table, okay? There's also an unnamed third person. Could be literally anyone. Also, there's a third person sitting at the defense table. I wonder if the unnamed third person and the person sitting at the defense table might at all be the same person. The Second Circuit, pointing to the established practice of replacing a defendant's name with a neutral noun or pronoun in a non-testifying co-defendant confession, held this is not a problem. The Supreme Court says not a problem. This is fine. This is totally fine. Not a problem. Yeah, this sounds totally fine. The confession was only admissible against the one guy, don't you know? And we never named the third person, even though there's only 3 people sitting at the defense table, and we named 2 of them. So we named 2 of them. We didn't tell you who the third person was, but there are 3 people. But you know, that's totally not. That's just an inference the jury could draw. They don't have to draw the conclusion. It could be the third person sitting conveniently at the defense table. Could be literally anybody. Okay, so no problem. This is totally fine. Stillwell's formal Mirandized confession to authorities is testimonial. Yeah, so they told him about his right to remain silent, and he's like, I don't want to remain silent. I'd like to tell you all about it. And for some reason that's unclear, he doesn't want to tell the jury about it. I don't know why. He was so thrilled to tell the police all about it. He was so happy to tell them. They told him he had a right to remain silent. He's like, I don't want to remain silent. I want to tell you all the things. But for some reason, he doesn't want to take the stand and tell the jury about all the things. I don't get it. He was so eager to talk to the police earlier. Why doesn't he want to talk to the jury? I don't know. But he wants to enforce his right to remain silent now. Okay, so we can use this against him. So we can use it against him because the witness is unavailable, because, you know, he has the right to remain silent, which you like to exercise now very much. And ordinarily, a witness whose testimony is introduced at a joint trial is not considered to be a witness against the defendant if the jury is instructed to consider that testimony only against the defendant. So yes, his confession can only be used against him. So we told the jury all about it. We didn't mention the third person by name at all. And we told the jury, hey, this confession is only to be used against the one person, man. It's only his confession. So don't use it against any other people that may or may not be sitting at the defense table. Long-standing practice permits the non-testifying co-defendant confession to be admitted at the joint trial, as long as we, tell you not to consider it. This practice is identified in early treatises and many states with similar constitutional rights. Notably, none of the treatises or cases suggest a confession naming a co-defendant must in all cases be altered to refer to another person. Thus, while it's unclear any alteration to the confession is necessary, so we're not even saying, for the record, the Constitution even requires that much. We're not even saying, for the record, that mentioning the other guy's name would have been improper. We've only said that you have to tell the jury they can only consider it on the one person. We never said you had to substitute a placeholder name. So, we're not even saying that much is required. Historical practice suggests altering a non-testifying co-defendant's confession not to name the defendant, coupled with a limiting instruction, is enough. So are you required to do that much? We're not going to tell you. But what you did is enough. So are you required to alter the name? Maybe, maybe not. But you did, and that's enough. So, some future prosecutor out there is going to try to get the name in, and we'll have a future case about it. But this is another problem for another day. The historical practice is in accord with the law's broader assessment that jurors will attend closely the particular language of limiting instructions and strive to understand and make sense of them. We believe jurors are smart jurors. We believe jurors follow the instructions of the court. We believe that jurors have sworn an oath to obey the instructions of the court, and the court told them. They told them you can only use this confession against the one person, no one else who may or may not be sitting against the defense table. There's a conspiracy that this guy says involved 3 people. We have told you the names of 2 of them. Those 2 people are sitting at the defense table. Also, there's an unnamed third person. Also, there's a third person at the defense table who may or may not be related. But we explicitly told you, jury, only use it against the one guy, no one else. And that's enough because jury is smart jury and will totally obey our instructions. The legal fictions are real. To disregard or make unnecessary exceptions to the principle will make inroads to the entire complex code of criminal evidentiary law and threaten other large areas of jurisprudence. The courts, in a case called Boutin, recognized a narrower exception to the presumption juries follow instructions, holding the defendant is deprived of the Sixth Amendment right of confrontation when the facially incriminating confession of a non-testifying co-defendant is introduced, even with a proper instruction. So, yes, we have said before that if it's facially incriminating, that is a problem. In that case, the prosecution introduced a confession by a co-defendant that implicated the guy by name. So, yeah, the court held that the confession's introduction substantially threatened the right to confrontation, reasoning there's some context in which the risk the jury will not or cannot follow the instructions is so great and the consequences of failure are so vital that the practice and human limitation of the jury system cannot be ignored. So while the original treatises, while the old treatises, and the Supreme Court is throwing shade on itself, incidentally, right now. The Supreme Court throwing shade on itself and saying, okay, in the original old treatises, we didn't require the substitution of name thing, but a prior Supreme Court, old la-di-da, a prior Supreme Court la-di-da said, you can't use the guy's name. That is too much, okay? You can't say it was me and Smith when Smith is sitting at the defense table, okay? You can't say me and Smith entered into a conspiracy, but you can say me and some other person unnamed was involved in a conspiracy while Smith's sitting at the table, and that's totally different. So no names, and the jury will obey that instruction. So if we said me and Smith, we think the jury might be too prejudiced. But if we just say it was some guy, any guy, may or may not be related to anyone at the defense table, that's totally fine. Okie dokie. The court in Gray later qualified this by holding that certain obvious redacted convictions might be directly accusatory, even if they did not specifically use the name. So, okay, you didn't use their name. That's great. But there were other details that may have clearly implicated the guy, right? So, yeah, it's like maybe the defendant mentioned the guy's name. It's like, okay, can you describe your co-defendant? I sure can. My co-defendant is a white male. He's age 42. He has thinning red hair. He sometimes has a scraggly beard. He's overweight. He sometimes wears a cowboy hat. Has piercing blue to hazel eyes, and is an accomplished lawyer. Right. So that is my co-defendant. And so we strike out the name, and it could be anyone fitting this description, who just happens to be, someone meeting that description who is sitting at the stand. It's like, yeah, that might be a little bit too specific. So yeah, just deleting their name may not be enough. You might have to delete a little bit more. The court in the prior law concluded that when redacted confession is simply places name with an obvious blank space, such as word is deleted, or a symbol, or similarly obvious indication, the evidence is so close that, not enough. So it's not enough to merely delete the name. You might have to go a little bit more to get rid of some other details that might somewhat suggest who it is. Those details are too much. It could be anyone. It has to be clear. It has to be clear. We're going to alter the confession. We're going to alter the confession so that it could be just anybody who may or may not be sitting at the defense table, right? So no names, no specific details. We'll edit it. We'll transform the confession to other words to avoid this problem. And it could be anyone involved in a conspiracy who may or may not be sitting at the defense table. Okay. The court precedents in this area distinguish between confessions that directly implicate the defendant and those that do so indirectly. So indirectly will be fine. Accordingly, none of our case law provides a license to fly-spec trial transcripts in search of evidence that could give rise to collateral inferences. So yes, you are now digging through the transcript, looking for any hints at all that could be alluding to the guy, but we're not going to let you do that. We're not going to let you look for little specks in the wind. So yes, there might be little tiny clues that it could be someone related to defense table, spattered throughout. There could be some clues, but just because there's perhaps some breadcrumbs is not enough. So the occasional breadcrumb is not enough. The admission of the confession, accompanied by a limiting instruction, did not run afoul of the court precedent The confession was redacted to avoid obviously naming the person, and it was not obviously redacted in a manner that would show that it was redacted. So close enough for us. Explaining the prior law in a way that Samia proposes would be inconsistent with longstanding practice and this court precedent, which would work unnecessary and imprudent changes in law and require federal and state trial courts to conduct extensive pretrial hearings because it would be impractical to fully police jury inferences. The likely practical consequence of extending the case law here would be manifest severance whenever the prosecution wishes to introduce the confession of a non-testifying co-defendant. So if we went this far, we would have to sever all those trials, and that would be really inconvenient. We'd really like to try you all at one time, save us money and save us time and save us energy. So, no, we're not going to sever all the trials. You get to sit next there. You get to sit next to Garrett with me and other party unnamed. And the jury can just draw any potential conclusion. And, we're not going to police the jury's conclusion and inferences because they've been instructed. They've been instructed, remind you, to only consider it against the one guy, not anyone else who may or may not be at defense table. So this is too much. We're not going to sever all the trials now. The proposal is not compelled by the Confrontation Clause and ignores the vital role joint trials play in criminal justice and the fact that confessions are essential to compelling evidence. Affirmed in Thomas delivers the opinion of the court, in which Roberts, Alito, Gorsuch, and Kavanaugh and Barrett join. Barrett files an opinion concurring. Kagan files a dissent, in which Sotomayor Jackson dissents 6-3. Thus, that brings us to the end of the opinion from the United States Supreme Court, in which we continue to learn that conspiracies are bad and conspiracies don't pay. If you're involved in a conspiracy, if any of your co-conspirators, testify at all and provide evidence to the police, that evidence can and will be admissible at trial. But don't worry, it's only admissible against them, and we're going to redact all their names, and it won't be clear that we did it in redactions, right? It will just be if they were in a conspiracy with somebody, anybody. It could be literally anyone of any description. Also, by the way, have you looked over at defense table? There's some people sitting over there. Also, could be literally anybody at all. So again, not a good idea to join a conspiracy because any of your co-conspirators testify or provide evidence to the police. Well, that can and will be used against them. Will not be used against you. It won't be used against you, and we'll make absolutely clear to the jury it's not to be used against you in any way. So I feel reassured. Don't commit conspiracies. And that, for the end of the moment, brings us to the end of discussion of this story. We're going to have to talk Kurt into making a Discord. Well, you don't have to talk Kurt into making a Discord. As it happens, Kurt has a Discord and has had a Discord for quite some time. So you can join my Discord if you like. It is there, and I would love to have you there. We even have a Midjourney room for you to create your Midjourney constructions. Push the button, says Dragon Book, because Dragon is best dragon. Push the button. Thank you. Yeah. So anyone can join my Discord, and you are welcome to do so. And we even have a Midjourney room where you can do the Midjourney thing. It is great. We are not creating a dog picture section. Let's see. Let's see. Where can you dump this into? I don't know where you can dump this into. I'm not sure I want you to dump it into general. I'm not even sure pictures are allowed in general. Put it in Midjourney. Even if it's not Midjourney created, you can put your photo of your dog in Midjourney. You can post it there because those are photos. You can dump your dog photo into Midjourney. Okay. Okay. If there is incredible demand, we may create an alternate room. But for the moment, you can dump it in Midjourney. Photos are allowed in Midjourney. Non-adult photos, need I say the obvious. In fact, not even anything that's adult adjacent. We're not that kind of room. If you want to pick pictures of your dog, probably okay though. You can't have a pet room. You can't have a pet room. If there's enough demand, we may split the room. All right. So if you guys really want a separate room for it, we'll see what the demand looks like. And if there's enough persistent demand, I'll create a separate room. But for the moment, you guys can have Midjourney. So until there's actual cause to split it, no. But if you guys use it enough and are active enough and there's enough demand for it, I'll create a separate room. It won't let you post. I doubt that's true. You should be able to post. You have to create. You should be able to post. You should have rights to create post. I have to now figure out why you can't post into Midjourney. You should be able to. Maybe you don't have permissions to create a post. Okay, I'll make sure that you have permissions. Attach files, I guess. Send messages. You should be able to. Okay. All right, I have to figure out what's going on in Discord now. Yeah, you have to create the thread first. You have to create the thread before you can post in the thread. You can't post a picture directly as what you're trying to do is you're trying to post the picture as the thread title. You can't do that. You have to create the thread and then you can post a picture in the thread you create. Yeah, you have to create you're trying to post it as the thread title. You can't do that. You have to create the thread and then you post it inside the thread. Yeah. So yeah, people are posting. Yeah, great. Yeah, it's a threaded uh it's a threaded channel. So it has sub threads. Okay, anyways. Okay. For today's United States Supreme Court case, we turn our attention to the issue of immigration and whether or not states can bring a complaint against the federal government in terms of how it enforces or doesn't enforce immigration law. Immigration law is thought to be the exclusive province of the federal government. There is certainly language in the United States Constitution that seems to suggest exactly that they have the ability to determine the rules for immigration. And it's up to the federal government to enforce those laws or not. So, can states say, hey, you're not enforcing your laws properly, or some rules are incompatible with your law? What are the rules of the states vis a vis federal law, vis a vis immigration? Let's get started with this. In 2021, the Secretary of Homeland Security promulgated new rules that prioritize the arrest and removal from the United States of non citizens who were suspected of terrorism or dangerous criminals who unlawfully entered the country only recently. For example, the state of Texas and Louisiana claim the guidelines are contravening two federal statutes that they read to require the arrest of certain non citizens upon release from prison or entry of a final order of removal. So the United States government says we are going to prioritize people to deport who are terrorists or dangerous criminals or recent people who have come to the United States. And the state of Texas is like, well, there are some other laws. You're required to arrest non-citizens as they come from prison. So after they're done with their time, you have to arrest them and deport them. And other people who have been given an order to be removed. You got to arrest and deport them. The district court found the states would incur cost due to executive failure to comply with these statutory mandates, and the states had standing to sue based on the cost. So, what is the basis of the states to sue? Is a pocketbook injury. By not doing this, you're creating a burden on us by having these people potentially in our states, creating a pocketbook injury for us. On the merits, the district court found the guidelines unlawful and vacated. The Fifth Circuit declined to stay the district court judgment, and this court granted certiorari to review it. So held, Texas and Louisiana lack standing to challenge the relevant guidelines. So, yes, as it turns out, there might be some federal law, but this is federal law, and Texas and Louisiana do not have injury enough to have standing. Under Article 3, a plaintiff must have standing to sue. The threshold question is whether states have standing. Based on court precedent, not so much. To establish standing, a plaintiff must show an injury in fact that is caused by the defendant and redressable. Have you been harmed? Is it due to what they did? Is there something we can do about it? The district court found the states would incur costs due to challenge policy, and monetary costs are an injury. But this court has stressed that alleged injury must be legally and judicially cognizable. So maybe there's an injury, but not one that is legal or legally recognized. That would require that the dispute is traditionally thought of as capable of resolution through a judicial process. Here, the states cite no precedent, history, or tradition of federal courts entertaining lawsuits of this kind. On the contrary, the court has previously ruled that where a plaintiff lacks standing to bring such a suit, when he himself is neither prosecuted nor threatened with prosecution. The relevant case law standing principle remains the law today, and states have pointed to no case or historical practice that would hold otherwise. There are good reasons why federal courts have not traditionally entertained lawsuits of this kind. For one, when the executive branch elects not to arrest or prosecute, it does not exercise coercive power over individual liberty or property, and thus does not infringe upon interests the courts are called to protect. So the executive branch, by not arresting someone, is not harming them because they're not arresting them. They're exercising prosecutorial discretion. So that is not creating a harm to them because, well, they're not being subject to the court's whim. Moreover, such a lawsuit would run up against the executive's authority to decide how to prioritize and aggressively pursue legal actions against defendants who violate the law. So, yeah, just basically prosecutorial discretion, right? There's a lot of people breaking a lot of laws. There's finite resources, even for the federal government. How are we to allocate these resources? It is up to the states to determine that. It is up to the executive to determine that, as the case may be. So all that stuff, and going from there. No more pictures in YouTube mod chat. No more dog pictures in YouTube mod chat. If you guys want your dog pictures, you have to take it to Mid Journey. Grr. I don't know how pictures of your dog are any way relevant to modding decisions or discussion of modding decisions or uh announcement of modding. It your dog photos are not relevant to YouTube modding. Get your dog photos out of my YouTube modding chat. I swear. The principle of the executive branch enforcing discretion over arrests and prosecutions extends to the immigration context. Courts also generally lack meaningful standards for assessing the propriety of enforcement choices in this area, which are invariably affected by resource constraints and regularly changing public safety and public welfare needs. That is why this court has recognized that federal courts are generally not the proper forum for resolving claims the executive branch should make more arrests or bring more prosecution. Sounds suspiciously like what we call a political question. It's up to the executive to determine how to do this. Please leave the courts out of it. This holding does not suggest that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecution. First, this court has adjudicative selective prosecution claims under Equal Protection Clause, in which a plaintiff typically seeks to prevent his or her own prosecution. Second, the standing analysis might differ when Congress Second, the standing analysis might differ when Congress elevates de facto injuries to the status of legally cognizable injuries were addressable by court. Third, the standing calculus might change if the executive branch wholly abandons its statutory responsibilities to make arrests or bring prosecutions. Fourth, a challenge to an executive branch policy that involves both arrest or prosecution priorities and provision of legal benefits or legal status could lead to a different standing analysis. Fifth, policies governing the continued detention of non citizens who have already been arrested arguably might raise different standing questions than arrest or prosecution policies, but this case presents none of those scenarios. So the court leaving itself some outs for some potential futures based on executive non action, but that isn't this case. Kestrel is now openly defying my policies as a Discord administrator. I am now there's an attempted rebellion by my moderators apparently in YouTube mod chat. Sandra, will you moderate Crystal, please? Uh, uh, I still have two more cases to discuss. I still have two more cases to discuss. I still have two more cases to discuss. Sandra, that sounds suspiciously like a threat to start posting photos in admin chat. I'm on to you. That sounds suspiciously like a threat to start posting photos in admin chat. I'm taking away everyone's rights. No one gets to have a moderate. No one gets to be on Discord anymore. The discrete standing question raised by this case rarely arises because federal statutes that purport to require the executive branch to make arrests or bring prosecutions are rare. This case is different from those in which the federal judiciary decides judiciable cases involving statutory requirements or prohibitions on the executive because it implicates the executive branch enforcement discretion and raises the distinct question of whether the federal judiciary may in effect order the executive branch to take enforcement actions. The court's decision does not directly indicate any view on whether the executive complying with the statutory obligations, nor does this court narrow holding signal any change in the balance of powers between Congress and the executive. Kavanaugh delivers the opinion of the court in which Robert, Sotomayor, Kagan, and Jackson join. Gorsuch concurs, and with Thomas and Barrett. Barrett concurs. Alito files a dissent in an 8-1 decision. Yeah, feel free to try to create beef fish for a swoop. Yeah, feel free to try to create some beef fish for a swoop. We will, if we get enough candidates, maybe we'll have a vote or something. That could be cool. Thus, that brings us to the case. Thus, that brings us to the end of the case of United States versus Texas, in which Texas complains the United States is not properly enforcing immigration law. But as the United States Supreme Court reminds Texas, this is a matter for the federal government and up to the federal government in terms of its execution. And the federal government has the ability to prioritize how it goes about different things, and different executives might make different choices. So the United States is not enforcing the law the way it wants, but that is in the nature of prosecutorial discretion and the nature of the executive discretion. So Congress could presumably do something different in trying to create damages or giving states the ability to sue, but they haven't done that. So it's up to the executive. And that, for the moment, brings us to the end of discussion of this story. Whew. Yeah. Will someone send me a link to Ian's Discord? Because I'm not sure I have it. Sandra, does anyone have a link to Ian's Discord? Because I don't know that I have a link to his Discord. Or if I do, I've lost it somewhere in my Discord tabs. Someone send me an invite for Ian. Just don't want me for a sunbeam. Sunbeams. No, I have lawn lumber. I don't seem to have Ian's for some reason. Don't expect me to cry. Wrong reasons, would rather die. Don't live and love me. Oh, is it just Roll of Law? I thought he had a different Discord. Is it just the one? Oh, okay. I thought Roll of Law. I thought Ian had two Discords. He just has the one. Okay, then never mind. I had a link to it. I was just confused. I'm so tired right now. Yeah, that beef fish is pretty good. That is a good looking beef fish. I'm going to copy that image and post it in the Discord room because that's a pretty good looking beef fish. Yeah. Then I have to figure out how to do the swoop. How does that work technically with the swoop? How does that work? Does he can I like hotkey that or something? And if so, how does that work? I don't know. I actually don't even know how to do a swoop technically. You hit the swoop button, that is not helpful. Insert short video. Yeah, how do you do that? Do you just go over the video and just press it manually, or is there like a hotkey for that or something? Huh. Yeah. We were trying to figure out how to do a swoop technically, Runkle. Do you have like a hotkey for the swoop that you just press a button, or do you have to like manually go into your like videos and manually play it? How does the swoop work technically? Because it feels like you guys are just pushing a button. No, I'm not in StreamYard, but I'm hoping that Melon will have the same thing. Excuse me. Okay, I'll take a look at it in StreamYard and see if I can set it up. I probably should just do it in StreamYard. Now StreamYard automatically stars things. Automatically stars super chats and stuff like that. I might switch back to StreamYard. All right. Anyways, we were doing United States Supreme Court cases Runkle. What's your availability, by the way, today? Uh, for doing script react. Do you want to do that like when I'm done with the Supreme Court stuff? Do you want to do that in like, I don't know, a half hour or something? Or what's your availability, Ian? Are you still busy with court or what are you doing? And you wait for people to type so that you can schedule things and yeah. You're available noon mountain, so that'd be like 1 my time. I'll probably be in the gym at that point. Most try to see if we can do something this afternoon, and we'll have to see if we can do it later today or something. All right. Okay. For today's United States Supreme Court case, we turn our attention to mandatory arbitrations and the impact it has on court processes. So many contracts today require that people go to arbitration, and people, of course, sometimes don't want to go to arbitration and want to go to a lawsuit. And sometimes there's a question about whether the arbitration process applies or whether a lawsuit applies and who gets to make that decision. And so this is sort of the interplay of that, right? We've got both an arbitration action and a court action underway. And someone's saying, okay, you have to go to arbitration first. And they're like, no, I want to go to court first. And it's like, well, I don't want to, let's go appeal and all the rest of it. So this is all about timing. When can courts get involved? When is arbitration? Who gets to decide in what order? So let's go ahead and get started with this. Abraham Belisky filed a class action on Coinbase, the crypto people who this channel is such a huge fan of because they once overtook his channel and led to the channel being deleted, which made me very, very sad. So I have a special place in my heart for the crypto people because they have burned me personally. Even though I never bought crypto or invested in crypto in any way, they still managed to spoil my life. So that's how bad they are. Anyways, Coinbase over here getting sued because Coinbase failed to replace funds fraudulently taken from user accounts. Because Coinbase's agreement provides for dispute resolution through arbitration, Coinbase said, how about arbitration? The district court said no. Coinbase then files an appeal to the Ninth Circuit, which authorizes an appeal from denial of a motion to compel arbitration. Coinbase also moved the district court to stay its proceeding pending resolution of the appeal. The district court denied the motion, and the Ninth Circuit likewise declined to stay. So the district court is all over here like, I have power to hear this. Coinbase is like, arbitration though. And the district court's like, nah, no arbitration for you. It's like, well, that's not fair. I want to appeal. It's like, okay, go appeal. And it's like, well, I want you to stay the proceedings while I'm appealing. No. And the Ninth Circuit's also like, no, we're not staying the proceedings. So, you have the right to appeal about whether or not we can hear the case, but in the meantime, we're going to hear the case. So, do we have to pause or not while we're trying to figure out the arbitration decision? Let's learn a little bit more. The district court must stay proceedings while the interlocutory appeal on the question of arbitration is ongoing. So, if appeal on arbitration is the issue, the district court has no power while that appeal is pending. The relevant law doesn't state whether district court proceedings must be stayed, but Congress enacted the provision against a clear principle prescribed by the precedent and appeal, including interlocutory appeal, to vest the district court of control over these aspects of cases involved in the appeal. The principle resolves this case. Because the question on appeal is whether the case belongs in arbitration or instead the district court, the entire case is essentially involved in appeal, and the relevant case dictates that district court must stay its proceedings while the appeal is arbitration. So if the appeal is on some side issue, you can proceed with other issues. So maybe it's related to an injunction or something. Maybe you can proceed on other issues, but you can't proceed on anything that's the subject of the appeal. And here, the entire issue is, can the court hear it? So the case being appealed on, can the court hear it? There's nothing left for the district court to do. So the district court was therefore required to stay its proceedings because the appeal vested power in that portion of the case, which in this case is the entire thing, in the Court of Appeals. Most courts of appeal that have addressed this question, as well as leading treatises, agree with the conclusion. The common practice of staying district court proceedings during pendency of the interlocutory appeal reflects common sense. If the district court could move forward with pretrial and trial proceedings while the appeal on arbitration was ongoing, then many of the benefits of arbitration, efficiency, expense, discovery, would be irretrievably lost, even if the Court of Appeals later concluded the case actually belonged in arbitration all along. So if the case was allowed to proceed, all those things would occur, and they're like, oh, the case shouldn't have been heard, then, we would have wasted a lot of time, money, energy in a fruitless process. So that seems stupid. Absent a stay, parties could also be forced to settle to avoid district court proceedings that they contracted to avoid through arbitration. These results are undermined by our standard that says that, you can't do this, you have to stay proceedings. I need water. I was so thirsty in class. Did I remember my water bottle when I left class last night? Or did I leave it at class? God damn it. I don't remember. Shit. Have I ever argued in arbitration? Once, but it got killed off very early in the arbitration process. So we didn't make it very far, but once. So it got killed off very early, which, happens. We made it to selection of a judge, and we made it to initial filings, and then the case was resolved. So, yeah, that happens. Happens a lot. Cases that actually make it all the way through to judgment are relatively rare in a lawyer's experience. Lots of cases terminate some point prior to ultimate judgment. The arguments to overcome the principle are unpersuasive. First, the courts of appeal possess robust tools to prevent unwarranted delay and deter frivolous interlocutory appeals that an automatic stay might otherwise encourage. Second, Congress includes explicit stay requirements in two other statutory provisions for reasons particular to those statutes, not because Congress thought an interlocutory appeal did not ordinarily stay district court proceedings. Third, the result here does not create a special arbitration preferred procedural rule, but simply subjects arbitration appeals to the same principles that courts apply in other analogous contexts. Fourth, experience shows that ordinary discretionary stay factors would not adequately protect parties' rights. In any event, the background of the rule applies regardless of how often courts might otherwise stay ordinary discretionary stay factors. Fifth, while the court has recognized that some questions of arbitrability are severable from the merits, the sole issue here is whether the court has authority involved in the appeal, and so they are not severable in this case. Reverse and remanded. Justice Kavanaugh delivers an opinion of the court in which Justice Jackson, Sotomayor, Kagan, and Thomas dissent, in a 5-4 decision. Okay. Thus, that brings us to the end of the case of Coinbase versus Belisky, in which case there is an issue over the arbitration agreement and whether the case should be arbitrated. The district court said no. They wanted to appeal. And they said, district court, you can't continue. And the district court's like, I totally can. But they can't continue because the entire issue is whether the district court can hear the case at all. So there's nothing for the district court to do. So applying standard precedent, this says, yeah, it needs to be stayed in a 5-4 decision. And that brings us to the end of discussion of that story. Push the button. Thank you, Trenton. I need water now. Excuse me. Water time. For uncivil water time. Water time, get some uncivil water time. It's water time for uncivil. Uncivil, gonna get some water time. Water time for uncivil. Water time for uncivil. It's water time in uncivil kitchen. Water time for uncivil. Water time for uncivil. Water time for uncivil law. Water time for uncivil. Water time for uncivil law. Oh yeah. Ah. Oh yeah. Oh god, it's glorious. Oh yeah. Water. Woo. Woo. Oh, man. Ooh, just like shotgun 20 ounces of water, man. Woof. Woof. All right, where were we? One more case. Okay. More water. More water. Mm. Look, man, the bottle's disappearing fast. Oh. All right. I feel better. Okay. For today's coverage, we cover a case dealing with what it means to illegally encourage or induce an illegal alien to come into, enter, or reside in the United States. So, illegal immigration, still illegal, amazingly enough, although perhaps under prosecuted and under enforced by our federal government. But this guy, they want to enforce it against. This guy was scamming people and to trying to get them to remain into the United States. So they want to prosecute him federally, not for the underlying scam, or not only the underlying scam, but also for inducing people to remain in the United States illegally. So, what does it mean to illegally induce someone to stay in the United States? And when is that a crime? Let's get started with this. Helem Hasen promised hundreds of non citizens a path to U.S. citizenship through what he called adult adoption. Incidentally, adoption is legal for adults. It doesn't happen very often, but yes, you can. I mean, normally we think about adoption for adopting a child, but legally, there's nothing stopping one adult from adopting another adult, which you'd want to do perhaps for the purposes of inheritance, for example, because then you're a child of that person. So yes, it is legal to adopt another adult. You may not have known that. What was the scam was not the adoption part, but that you'll get citizenship through this. That was the scam part, not so much. Because you're not a natural born citizen, right? And just becoming a child of them doesn't make you a citizen. So no. Anyways, he earned $2 million from this scam. The United States charges him with, among other things, forbidding the United States. The United States, no, The United States charges him with other things, a statute which forbids encouraging or inducing a illegal alien to come into, enter into, reside in the United States knowingly or in reckless disregard of the fact the activity is or in violation of law. He moves to convict, he was convicted and he moves to dismiss the charge on First Amendment grounds. The district court rejects the argument, but the Ninth Circuit concluded the clause was unconstitutionally overbroad. So, is there a problem with a law that forbids someone from encouraging someone to remain in the United States illegally? I like the guys. I like the beef fish stuff you're creating. It's good. All right. Because the relevant law forbids only purposeful solicitation and facilitation of specific acts known to violate federal law, the clause is not unconstitutionally overbroad. The First Amendment overbreadth challenge rests on the claim the clause punishes so much protected speech it cannot be applied to anyone, including him. A court will hold a statute facially invalid under overbreadth if the law prohibits a substantial amount of protected speech relative to its plainly legitimate sleep. So we are concerned about making sure that a law does not cover too much protected speech. In such circumstances, society's interest in free expression outweighs the interest in statutes' lawful applications. Otherwise, courts must handle unconstitutional applications as they do, case by case. The issue here is whether Congress uses the term encourage and induce as terms of art, referring to criminal solicitation and facilitation, thus capturing only a narrow band of speech, or instead, as those terms are understood in ordinary conversation, thus encompassing a broader swath. Criminal solicitation is intentional encouragement of an unlawful act, and facilitation, otherwise known as aiding and abetting, is providing of assistance to a wrongdoer with intent to further the offense's commission. Neither requires lending physical aid, for both words may be enough, and both require an intent to bring about a particular unlawful act. The terms encourage and induce found in the clause are among the most common verbs used to denote solicitation and facilitation. Their specialized use is displayed in the Federal Criminal Code as well as the criminal laws of every state. If the challenge statutes use those terms as typically understood in the criminal law, an overbreadth challenge would be hard to sustain. Hasten, like the Ninth Circuit, insists the clause uses encourages and induces in an ordinary rather than specialized sense. In ordinary parlance, induce might mean to lead on, influence, prevail upon, move by persuasion or influence, and encourage might mean to inspire with courage, spirit, or hope. If the clause convey these ordinary meanings, it arguably restricts abstract advocacy or general encouragement, and its applicability to protected speech might render it vulnerable to overbreadth. So, yes, it is generally legal to encourage people in a very generalized way to break the law, right? As long as it's not imminent, right? As long as it's not imminent, so you get into incitement. So, when you're talking about solicitation, when you're talking about this kind of idea, right, to a specific individual, right, to a specific people or a defined limited group of people, right, you can have solicitation. But if you are like people in general should break this law, it is good for people in general to break this law. This law is a dumb law. People should not obey this law. I don't like the law. People in general should break it. As long as it's not going to happen right now in a way that's going to constitute violence, right? That is not solicitation. That is not accessory, right? That's just engaging in political speech. So yes, you can get up and generally encourage people generally to generally break the law as long as it's not imminent and won't result in imminent harm. But when you talk about an individual or a defined group, not so much. So which of these twin meanings should we be in? The court holds the clause that uses encourage or induces in its specialized criminal law concept, that is, solicitation and facilitation. So, yeah, you can't encourage a specific person to break the law or induce a specific person to break the law, or you can't help them in breaking the law. That's aiding and abetting. So, you can't facilitate them, you can't help them, you can't encourage them, you can't command them. That is solicitation, that is facilitation, that is aiding and abetting. You can't do that. So as long as we understand it that way, it's not a problem, and that's how Congress meant it. Context indicates that Congress uses the words as terms of art. Encourage and induce have well-established legal meanings. And when Congress borrows terms of art, they presumably know and adopt those ideas. Yeah, I mean, there are terms that are well understood. We don't have to redefine every single legal concept. Some terms are well understood. Congress, of course, can redefine terms, but they don't always have to, because a lot of terms are well understood, and these are part of them. That inference is even stronger here because the clause prohibits encouraging and inducing a violation of law, which is the object of solicitation and facilitation. The Ninth Circuit stacked the deck in favor of ordinary meaning, but should have given specialized meaning a fair shake. When words have several plausible definitions, context differentiates. Here, the context of the words indicates that Congress uses them as a term of art. I noticed that my chat has completely gone to hell, and I've lost about 100 people watching today. I had 250 people watching. Now I only have 140 people watching. Where have I failed? Where have I failed the chat? Where have I failed as a creator? Where have I failed to keep your attention? I thought I was doing so good. I thought I was doing so good with energy levels. Is it just that it went on too long? Is it just too much? Why have I failed? Hmm. Am I not bringing enough energy? Am I not being personable enough? I need to have more of a personality like Rob, or more of a personality like Peter Tragos or something. I need to change my entire personality. I don't know. I'm not sure how to do that. That sounds really hard. Uh, hmm. Hmm. Statutory history is an important part of relevant context. When Congress enacted in 1885 would become the template for the clause, it criminalized knowingly assisting, encouraging, or soliciting immigration under contract to perform labor. Then, as now, encouraged has a specialized meaning that channeled accomplish liability. And the words assisting and soliciting, which appear alongside encouraging, reinforce the narrower criminal law meaning. When Congress amended that provision in 1917, it added induce, which always carries solicitation and facilitation overtones. In 1952, Congress enacted the immediate predecessor for the clause and also simplified the language from 1917, dropping the words assist and solicit and making it a crime to willfully or knowingly encourage or induce or attempt to encourage or induce either directly or indirectly the entry into the United States of any alien not lawfully entitled to enter or reside within the United States. Hassan believes these charges dramatically broaden the scope of the prohibition on encouragement, but accepting that argument would require the court to assume that Congress took a circuitous route to convey a sweeping and constitutionally dubious message. The better understanding is that Congress simply streamlined the previous statutory language. Critically, the terms Congress retained, induce and encourage, substantially overlap in terms with the meaning of submit, assist, and solicit. The clause is thus better understood as a continuation of the past. Oh my God. Hassan argues that the absence of an express mens rea requirement means the statute is not limited. Hassan argues that the absence of an express mens rea requirement in the clause means the statute is not limited to solicitation and facilitation. But when Congress placed encouraged and induces in the clause, the traditional intent associated with solicitation and facilitation is part of the package. The federal aiding and abetting statute works the same way. It contains no express mens rea requirement, but implicitly incorporates traditional state of mind requirements for aiding and abetting. The clause is similarly situated among other provisions that function in the same manner. Since encourages or induces draws on same common law principles, the clause incorporates the mens rea requirement implicitly. Finally, it bears emphasis that the canon of constitutional avoidance counsels the court to adopt the government's reading if it's at least fairly possible. The relevant law reaches no further than purposeful solicitation and facilitation of specific acts known to violate federal law. So understood, it does not prohibit a sweeping amount of protected speech, plainly relative to its legitimate sweep. It's undisputed the clause encompasses a great deal of non expressive conduct, which does not implicate the First Amendment at all, namely smuggling non citizens into the country. Because these types of cases are heartland clause prosecutions, the plainly legitimate sweep of the provision is extensive. To the extent the clause reaches any speech, it stretches no further than speech integral to unlawful conduct, which is inherently unprotected. Hassan, on the other hand, fails to identify a single prosecution for ostensibly protected expression in the 70 years since Congress enacted the immediate predecessor. Instead, he offers a string of hypotheticals, all premised on expansive ordinary meanings of encouraged and induced. None of the examples are filtered through traditional elements of solicitation and facilitation. Most importantly, the requirement that the defendant intended to bring about the specific result. Because the clause does not have the scope he claims, he does not produce the horribles he parades. Hassan also resists the idea that Congress can criminalize speech that solicits or facilitates a civil law violation, and some immigrant violations are only civil. But even assuming the clause reaches some protected speech, and even assuming the application to all speech is unconstitutional, the ratio of unlawful to lawful applications is not lopsided enough to justify a facial invalidity. So maybe as applied challenge in some cases, possibly, but not on its face. Barrett delivers the opinion in the court in which Jackson and Sotomayor dissent in a 7-2 opinion. Thus, that brings us to the end of the case of United States versus Hassan, who Mr. Hassan over here had a scheme. He had a scheme to illegally induce people to come into the United States and said, you can be citizens of the United States through an adult adoption. It wasn't true, but he managed to scam people out of $2 million. He did some illegal things. One of the illegal things he did was by the very act of encouraging them to come into the United States. He's like, that's not fair. The statute governs free speech. And there's the court's like, no, it doesn't. It doesn't. It makes it illegal to solicit or to assist in a facilitation, and that's all it means. And Congress used different words, but different words that mean legally the same thing. So maybe as applied. Is there an as applied challenge? Yeah, possibly. There might be some situation in which your speech is constitutionally protected, but you're trying to strike this down on its face, and no. So not so much with the facial challenge for you. Also, probably not so much with the as applied challenge to you, by the way, either, because you were clearly trying to induce them for an illegal purpose. So no. So whatever might be true of someone, it's not true of you. And that brings us to the end of discussion of this case. Oh, I'm losing traffic to EDB. Oh, okay. Yeah, maybe I'm losing traffic to EDB. That's okay. Push the button. Oh, we don't have to incidentally because I'm done, but it's always a good reminder. Don't stress much about the numbers. I stress a little bit about the numbers because it's my job. I stress a little about the numbers because it's my job. This is my profession now. I've been doing this full time for a year. So me stressing about the numbers is me stressing about my customer base, which seems like a thing that a owner of a business would be concerned about. An owner of a business is concerned about the numbers. He's like, how can I get more customers? How can I increase the quality of my project? Why am I not getting enough consumers? What is it that is driving people to my, well, I won't call them competitors because I don't really consider them competitors. Let's call them compatriots. Why are my numbers off compared to my compatriots? What is it about me or my channel or what I'm doing that I am not providing the product that my customer wants? To the extent I'm losing viewers to EDB, it is because EDB is in some sense producing a superior product to me. Presumably, I mean, because they're choosing EDB over me. So it is therefore implicitly true that she is supplying a preferred product. So it's like, well, what can I do to make that preference the other way around? Because it's like, how can I provide a better quality product so that my consumer will choose me? How can I up my numbers? How can I up my subscriptions? How can I make this a better channel? I'm always constantly striving. I'm always constantly striving. Like I changed my thumbnails recently again to try a different style and see if that helped. I try different things all the time. I try mixing up the story content. I try mixing up things to try to see what can I do to make my product a better product. And so, you know, it's like, how can I improve the quality of my product? I look at, Rob's law. I look at Rob's live numbers. I look at Ian's live numbers. I look at EDB's live numbers, and I'm like, what can I do to appeal to an audience that I can get, or Peter Tragos's numbers? It's like, what can I do to refine and refine my product so that I'll get those kinds of numbers? What can I do to make my product a more desirable product? So I think on some level, I'm just asking fundamental questions any person would ask of any business. It's like, how can I get more feet in the door? What is it about my product? What is it about my store? What is it about things that can make things better? So each channel is a specific personal brand. You can't directly compete. Well, that goes back to my original point that maybe it's something about me and something about my personality. So, like, yeah, that goes back to my original point that, like, maybe the problem is fundamentally me. And maybe I need to change my personality in some way. Because if the product is if the product is personal, which I think is probably true, if the product is the personal brand, if it's the brand, if it's the personality, if it's the persona that is the driver for the channel, which I think is probably largely accurate. I think that's a valid observation. Then the natural question is, okay, what is it about my personality? What is it about my persona that is not as attractive, for lack of a better word, compared to other people's personalities and personas? Is it possible for me to change my personality or persona in a way that would better be a better wanted by the market? So if the driver is the personal brand, how do I change the personal brand in a way to be a better driver? It's like, how do I change me as a person? It's like, how do I change that to appeal to a wider audience? So yeah, I look to that consideration too. So I'm always looking, like, how can I improve the content? How can I improve the delivery? Is it the thumbnails? Is it the title? Is it the video description? Is it me? How do I change things? How do I improve things? How do I make it better? How do I drive things to ever higher levels? And I'm perfectly comfortable with the prospect that it's me. And that's why I asked the question, how do I change me? How do I change me to fix the problem? So it's like I'm just considering everything. Yeah, I mean, other streams doesn't really fundamentally answer the problem. If the issue is other streams, the issue is why people are choosing other streams over me. So the fact that there are other streams doesn't really solve the problem, because the question is, why are they choosing my competitor over me or my compatriot over me? Because competitor is not really a fair term. So yes, there are multiple different streams. Why are they choosing those streams and not my stream? How can I make them choose my stream? So just things I think about. I think about a lot. Shirt and tie. Okay. Shirt and tie. I could try shirt and tie. I could try suit. I was very turned off by you at first because of the way the chat was going. Then actually to listen to what you had to say about the law, and I can't imagine the day without you. That's nice. Thanks. Well, I'm going to sign off for now. First of all, I need lunch. Second of all, I need a nap. Third of all, I need gym. And then I need improv class tonight too. I've got a lot to do today. And at some point, I've also got to edit this stuff. So I got a lot of stuff. So yeah, maybe suit and tie. I'd like to lose some more weight before I do suit and tie because it's a little uncomfortable. But maybe later, or maybe I'll figure out something. Yeah, maybe suit and tie. Maybe I need more of a background that would be more akin to like legal and put on a more professional persona with suit and tie and a more professional background. Maybe that's the way to go. Maybe the hat is too juvenile. I don't know. Hmm. I'm going to sign off for now. I need lunch. In terms of that, I'm going to sign off. I hope you've had a wonderful stream. I've enjoyed streaming with you. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.